Lordship, on mentioning a matter, this is
If it is extremely urgent, don't mention. Today is not the usual mentioning day. Mentioning day is on Monday. Yesterday I allowed mentioning for 45 minutes. What is the urgency?
Lordship, the petitioners are successful candidates of SLST
Yes.
this year examination.
Yes.
They mistakenly chose the mode of instruction as English medium instead of Bengali medium, and the recruitment process is continuing. If the matter is not
This stage is over. Written examination stage is over. When I was on and then in the regular determination, I passed several orders. But now that stage is over.
this matter was in determination of Honorable Justice Amrita Sinha's
Yes.
Lordship.
Now,
There's no
after written examination, what is the scope?
There's
Written examination is over.
Yes, Your Lordship.
So then,
It can be fixed under new motion, Your Lordship. They inadvertently chose the mode of instruction. They thought the instruction means the instruction they are going
now
to give
what is the urgency? Why you will not?
Urgency is, my lord, the recruitment process is continuing. If the matter is not heard, this writ will become infectious. Your
When
Lordship.
recruitment process will end?
I need to take instruction on that, my lordship.
Day after tomorrow, দিয়ে দেবেন.
Much obliged, Your Lordship.
Sir, notice upon the learned advocate representing commission.
Lord.
Yes, please call the list.
Item number 1.
Yes.
This is a matter regarding the promotion that has been going to start in the month of January. It was mentioned a couple of times, Lordship, but it is appearing in the combined list. Yesterday it was mentioned not by me, Lordship, but
You are appearing for the petitioner?
so I am appearing for the petitioner.
So I was under the impression that the learned advocate who was representing the petitioner, who was mentioning, he is appearing for the petitioner, and he prayed for release of the matter.
Lordship, may kindly do that, Lordship.
Yes.
Lordship, may kindly do that. I have instruction from my client, Lordship. The client has instructed me to under instruction. I am submitting this, Lordship. May your Lordship.
But this matter was taken up on 4th November 2025,
Lordship, that
and
is,
it was wrongly filed.
no, Lordship.
And
prior to
today
that,
you are
Lordship.
praying for release.
No, Lordship, prior to that, Lordship, it was moved to the honorable bench, Lordship. Maintainability point was raised by the learned advocate appealing for the opposite party. They had raised the maintainability point, Lordship. For that, it was fixed on 4th November. But 4th November, Lordship, after change of determination, it went before the honorable bench of the Roy.
It's a group 2 matter.
Group 6 matter, Lordship. Group 6. It was hard on 2 occasions, Lordship. They had taken the maintainability point that was being heard, Lordship. And it was thereafter it was mentioned by me, Lordship.
This is recorded in the order that writ petition actually pertains to group 6, but by mistake,
Yes,
the classification
that had happened,
was mentioned as group 2.
That had happened, Lordship. That had happened. That is the reason, Lordship, it went with Justice Roy to Justice Roy's bench, Lordship, when the change of determination had happened. But thereafter it was released and it appeared before your Lordship. I mentioned this matter, Lordship. It was included in the monthly list of December, but as at number 246. But
Yes. But what is the urgency? That matter requires release?
Lordship, I did not ever pray for release, Lordship.
Yes.
I do not ever pray for, but the petitioner, Lordship, the client is so, Lordship.
First of all, this was moved on 4th of November. Then it was wrongly classified as group 6 group 4, but in the order it says it is recorded that since this petition actually pertains to group 6, but by mistake classification heading has been mentioned as group 2.
Prior to that, it appeared on 31st October. When the advocate appeared for the other say, Lordship, they raised the maintainability point. It was hard. The order is there, Lordship. 31st October. They raised the maintainability issue, Lordship, that was being heard, and for that it was fixed on 4th November. But since the change of determination had happened.
First of all, this was moved before a bench did not have determination. Then there was a leave granted to amend the classification presentation form. It was amended, and now it is being mentioned that either take it or release it.
It had originally appeared before the honorable bench having determination.
What is the urgency?
On 31st October,
What is the urgency?
there was an order passed, Lordship.
What is the urgency?
Lordship is that, Lordship, the promotional criteria, Lordship, the promotional procedure is going to start in the month of January. And it is to be undertaken.
That's why we're leaving all other matters. Your matters will be taken up. Then
I had never submitted.
issue.
I had never submitted, Lordship. I have the written instruction from my client, Lordship. Kindly take it.
Matter was mentioned for giving precedence at the time of hearing. On the ground of urgency. Matter was mentioned on 15th December 2025. তারপরে যেটা বললাম,
Lordship will kindly take note of the order dated 31st October, Lordship. 31st October.
However, court is not satisfied on the ground of urgency requiring the matter to be given precedence. Stop. Learned advocate representing the petitioner prays for release of the matter. And accordingly, learned advocate representing the petitioner prayed for release of the matter. And accordingly, matter is accommodated in today's list under the heading to be mentioned. Stop. Next paragraph. The writ petition stands released and be placed before the is there any other bench?
Lordship, there is no other bench, Lordship.
The writ petition stands released. Stop. Learned advocate representing the petitioner shall be at liberty to take appropriate steps.
Lordship will not take me amiss, Lordship. Lordship will kindly not take me amiss, Lordship, for this, Lordship.
Next matter, please call the next matter.
Item number 2 and 3.
Extension.
This is for interim order. Vacating interim order.
Yes, it was mentioned for extension of interim order.
No, but there was an interim order, of course.
Duto matter আছে একসঙ্গে.
There are two matters.
Last day I submitted the report of the.
Just a minute.
Petition এটা বেশি।
But it was mentioned for extension of interim order. Otherwise, it is appearing under the who has mentioned this for extension. Because there was a direction, Mr. Mojumdar, on 19 December that matter to appear under the heading motion in the monthly combined list. Now today it is at the under the heading extension of interim order.
14th October during vacation there was an
এটাকে extension কে mention করেছিল? Mentioning slip কোথায়? Because on a similar issue, another writ petition was dismissed against which appeal preferred.
Yes.
Appeal was dismissed.
Yes.
Now, as a result whereof, court directed
Praying for vacating the interim order.
one Abu Sahil.
Abu Sahil Kadu.
Yes, my lord. May I submit, my lord, subject to lordship's consent?
For extension of interim order.
Yes, my lord. There is an order, my lord. If your lordship kindly sees that item number 3, that there is an interim order up to 15th December. For such reason, my lord was kind enough to direct the matter to appear before the monthly list. Malad 15th December, up to 15th December. Malad, if your lordship kindly see, we have placed the order before your lordship also.
When this interim order was passed,
Malad,
Yes,
during the
but-
vacation
but
bench,
in
Malad,
item number 3, there was an interim order. Since the first writ petition was not being taken up, and in the meantime,
23940.
Right.
দেখি 23940 টা কোনটা?
23940, yeah.
দাও। Yes, when the order was passed, interim order.
14th October.
Let the interim order be extended for some time, for a limited period, and the matter shall retain its position in the list. Issue.
Praying for bracketing the interim order.
At this stage, it is let the matter be extended, and already the matter is appearing under the heading motion. Matter to be heard on merits. Yes. Issue. Matter has come. Matters have come up in the list for extension of interim order dated 14th October 2025, passed on the writ petition being WPA 23940 of 2025. Stop. Next paragraph. On perusing the order dated 14th October 2025, passed by a coordinate bench, it appears that the interim protection which was granted was for a limited period, comma, up to 15 December 2025. Next paragraph. Let the interim order passed on 14th October 2025 be extended till 31st till 27th February 2026 at 2026 or until further order. Stop. Let matters retain its position in the monthly combined list dated 1st December 2025.
Malad, as item number 100, Malad, it is appearing before your lordship, item number 100.
Yes, yes.
Malad, I'm grateful.
Well, this order is with respect to item number 3. Item number 2, there is no interim order.
Perhaps you have not heard my dictation.
Sorry.
I have specifically directed, go through the order.
Yesterday I have submitted.
That is in connection with WPA 23940.
Great.
Yes,
Sorry.
please call the next item.
Item number 4.
Yesterday 4 I am for the petition.
Yes. I will consider it at a time of hearing of the motion.
I am for the petitioner, my lord. Lord, this petitioner participated in the second SLST, my lord. My lord, in connection with first SLST, he is a
For the commission, my lord, Mr. Bandopadhyay is online, my lord, kindly allow his.
Yes, দেখো তো online কি লিখছেন?
now.
Yes, yes.
Now he is an untainted teacher in connection with first SLST, my lord. He is still serving pursuant to the order passed by the Honorable Supreme Court dated 17th of April 2025 until 31st of December, my lord. Now in connection with second SLST, my lord, his subject is Bengali. My lord, he participated, and when the verification list was published on 15th of November, my lord, he finds that he shortfall for only 1 mark. Now, if your lordship kindly takes up my
Verification list shortfall of 1 mark in regarding
for
what?
getting qualified for verification and interview.
In the written test,
Well,
there-
I am appealing for the School Service Commission.
yes.
Well, in the
In the
detail,
written test, there is a shortfall of 1 mark.
in the written test combined with the academic qualification and teaching experience. So total course score calculates of the three segments, my lord. In the total calculation, he is shortfall for only 1 mark. Now, in respect of question, kindly takes up page 7, my lord. Now, when the preliminary answer key was published, my lord, there was a provision to raise objection or suggestions before the commission by depositing 100 rupees per question. So, in respect of this question, my lord, this petitioner raised objections.
Which
Well,
question?
The question appearing as at page 7. Page 7 of my writ petition.
Page 7.
May I place the question, my lord?
Now you want that this that correctness of this question is to be determined for permitting the petitioner to participate in the
Yes.
examination.
Yes.
This bench.
No, my lord. My lord,
Yes.
I am saying that in respect of this question, the answer option chosen by the commission is answer option B. My lord, I can show before your lordship, I can demonstrate before your lordship that in respect of these questions, my lord, textbook endorsed by the West Bengal Board of Secondary Education, which is taught in the classes 9 and 10, my lord, this answer option is answer option C. As many as, if your lordship kindly takes up, my lord, as many as 4 references I have quoted in the writ petition. I have annexed all the references, but I am praying that let them file a report saying that my answer is wrong.
Yes, Mr. Bandyopadhyay.
But initially, when the preliminary objections have been raised in terms of the rules, all we have sent to the expert committee. An expert committee has given their reports, and on that basis, he has also not succeeded there.
No, he's saying that he participated and on accumulation of marks relating to written and academic score, the list is published where he will not be permitted to participate in the personality test since his marks falls short of 1 mark. Falls short of 1 mark.
It falls short
Now,
of one.
if this question is adjudged as a correct answer, in respect of this question, if correct answer is given by the petitioner, in that event there will be an enhancement of 1 mark.
Yes.
That is the
Correct. But the expert committee has rejected his case. Whatever the expert committee the report is there, the answer, we have to go by that answer.
Then Mr. Bandyopadhyay file a report.
Now I will file a report, but kindly can I cite one judgment to us? These points have been considered in so many matters.
No, today court will not pass any interim order. I'm expressing my mind. Today court is not going to pass any interim order. You file a report in the form of affidavit, and that the selection process or interview is to be held subject to result of this.
My lord, I am obliged.
Today, I am not directing the commission to permit the petitioner to participate in the examination, in the personality test.
Very nice, Millard. Only one thing, just your lordship, just consider just that in a number of matters, on the threshold, this has been dismissed and reasoned order has been given by the.
No, at this stage, since this is not a regular bench, Mr. Bandyopadhyay.
Okay,
Yes.
okay. Well, no
But
problem.
similar type of order has been passed by the earliest bench.
Yes, sure. Petitioner affidavit of service.
Yes.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner participated in
Second
state level selection test 2025, and the grievance of the petitioner is he will not be permitted to participate in the ensuing personality test since marks awarded to the petitioner in written examination and academic score.
This is marks regarding written examination.
Marks awarded to the petitioner is not adequate to make the petitioner eligible for participation in the next round of selection process. Next paragraph. However, petitioner has questioned correctness of the question and answer key. Correctness of the answer key. Correctness of the answer key to question number 4. To question number 4 of Bengali paper.
My lord.
Question number 4 of Bengali paper.
My lord, question booklet series B.
Where?
My lord, paragraph 12.
No. Take me to the relevant page.
Achha.
Page 49.
Yes. Question booklet series D.
D, then serial number 4.
4.
কি বলছিলাম?
49.
4 of question booklet series D, comma Bengali.
Bengali.
Stop. It is submitted that if it is considered that petitioner has opted right answer to said question number 4, in that event there will be enhancement of marks which would make the petitioner eligible to participate in the next round of selection process. Next paragraph, Mr. Kullan Bandyopadhyay, learned senior advocate representing West Bengal Central School Service Commission, appears on virtual mode and submits that issue was sent to the subject expert, and it is found that there is no anomaly in answer key. Next paragraph. Concerned authority of West Bengal Central School Service Commission is directed to file a report in the form of affidavit by 1 week after ensuing Christmas vacation, disclosing the correctness of answer key to question number 4, comma question booklet series D, comma Bengali. Stop. Next paragraph. At this stage, court is not inclined to interfere with the selection process, but same shall be subject to final result of this petition.
Obliged, my lord.
List the matter under the heading. List the matter under the heading motion before the regular bench 2 weeks after ensuing Christmas vacation.
Item number 5.
My lord, I am for the petitioner, my lord. My lord, this is my affidavit of service.
Same.
Same.
No.
All are same issues, different subject.
Different, sir. This is,
Different question.
my lord, this is with respect to history, my lord. Here, my lord, I have 2 grievances. My lord, one, I am saying that first question is out of syllabus.
Page 48.
Yes, my lord. Question booklet starts from 48.
History.
History.
History C.
History C.
Question booklet series C. Question number
My lord, 15, 13, 23, 35. My lord, in respect of 15, I am saying this is out of syllabus. And in respect of out of syllabus, they have already awarded score in multiple questions to all candidates.
some of the questions are out of syllabus.
Question number 15 is out of syllabus. I have annexed the syllabus also. Question number 13, my lord, 2 possible answer. I have annexed reputed international books as well as national books.
What are those questions which are out of syllabus?
Question number 15.
15. And so far other 13, 23 and 35?
My lord, in respect of 13, my lord, commission says answer C. We are saying answer D also. Both possible answers.
So therefore answer key issue.
In question number 23,
my
lord, commission says answer C. I am saying as well as answer A. There is also 2 possible answers. I can show, my lord.
So the 13 and 23 is same. Issue is same. In connection with question numbers 13 and 23.
Yes.
Yes, then.
Question number 35, my lord, all options are incorrect.
Answer key.
All answer options are incorrect.
Issue. 11, 12.
11, 12. History.
Previous matter, it was 9, 10 or 11?
11, 12. All 11, 12.
একটু বলে দাও তো দেখি এবার। শুনেও নিও। একই অর্ডার হবে, শুধু এই জায়গাটা চেঞ্জ। পড়ো, একই অর্ডার হবে। না, সেকেন্ড স্টেট লেভেল SLST পড়ো 2025 for classes 11 and 12. দাঁড়া, হি or she কিনা দেখে নি। প্রদীপ্ত চন্দ্র, হি। And he will, হ্যাঁ।
অবজেকশন দেওয়া আছে এই তো 15।
Yes, next, তারপর বলো, এটা সেম এই ম্যাটারে, হ্যাঁ। এই জায়গাটা চেঞ্জ হবে। Petitioner has questioned. Now, petitioner, it is submitted on behalf of the petitioner that he participated in the aforesaid selection process in history, and he raised objections regarding question numbers 13, 15, 23, and 35 of history. Stop. Under question booklet series C. Stop. It is contended that options being answers to question numbers 13 and 23 না, it is contended. Now, it is contended that there are incorrect key answers to question numbers 13 and 23. And question number 15 is out of syllabus. Stop. According to the petitioner, all options being answers to question number 35 are incorrect. Stop. তারপরে কি ওখানে বললাম?
Lordship, in this matter, I am appearing on behalf of the state.
Yes. Now, it is submitted that if the defects as indicated in aforesaid 4 questions are correctly addressed, there would be enhancement of marks which would make the petitioner eligible to participate in ensuing personality test. তারপরে কি বলেছি? And there is no anomaly in the questions, in those questions. Stop. তারপর আরেকবার পড়ো। না, disclosing the correctness of question and answer key in respect of aforesaid 4 questions, namely 4 questions of question booklet C series, history, namely question numbers 13, 15, 23 and 35. তারপর result.
Grateful.
Record appearance of Mr. Boishu for the state.
I am grateful.
Item number 6. This is my affidavit of service and payment of deficit court fees. 3 petitioners. Same question, one single question.
Same, my lord.
Page 82.
First one. Or this is which subject?
Mathematics, question booklet series C, question number 55, appearing at page 82 of the writ petition.
It is clear.
82, my lord. Page 13 of question booklet series and running page 82. Kindly see question number 55.
First page of the question.
First page. 70? 70, my lord.
You are questioning which answer key to which question?
Question booklet series C.
Yes, but which question number?
55, appearing at page 82.
What is the defect in that question?
Yes, my lord, kindly see the defect. My lord, answer option A and B is same.
55.
Yes. Question number 50.
Page
82. My lord, kindly ignore the rough portion, my lord. Top right corner. My lord, answer option A and B is same. They have chosen answer option A. I am putting this question to myself, why not then B?
issue. ঠিক করি না সেম না সাবজেক্ট ডিফারেন্ট ফার্স্ট এসএলএসটি বলো ফার্স্ট এসএলএসটি সেকেন্ড এসএলএসটি for classes 11 12 in mathematics. $55. Question number 55.
But with your lordship's leave, may I keep
Yes,
with
yes.
you- These are not same, man.
Yes, question number 55 of question booklet series C, mathematics. According to the petitioner, option A and B being correct answers, being probable answers to question number 55
My lord,
is same and identical.
yes, option A and option B is identical. But if we calculate the math, my lord, answer comes otherwise. We have calculated the marks in the writ petition also.
I am not expert, subject
My lord.
expert, but your contention is this, that A, B is
Is
the
same.
same.
We have opted options B.
Stop. Petitioner opted B.
Yes.
Petitioner opted capital B করবে সব জায়গায় within bracket. Petitioner opted capital B, whereas A was whereas answer A was considered as correct answer. Whereas A was considered as correct answer. Whereas A was considered as correct answer. Stop. According to the petitioner, if A was considered as correct answer, then the option made by the petitioner in according to correct answer, then B also is required to be considered as correct answer, and petitioner opted B and was not awarded marks. Stop. তারপরে কি আছে দেখো তো সিম্পল। 55 of the petitioner. There are three
petitioners.
Petitioners. The issue is same order.
Well, I paid the deficit court fees.
Disclosing correctness of answer. Correctness of answer key to question number aforesaid question number 55. তুমি থাকবে এটা শেষ হোক।
Item number 7. 7, my lord. Payment of deficit court fees to petitioners. Common question.
You mentioned this matter as an urgent matters.
Yes, because the interview
that to be taken up before 23rd.
My lord, we have mentioned before the earlier
That's
page.
why court disbelieve lawyers.
Well,
I'm telling you.
Well, we have.
If it is truly urgent, you could have mentioned this matter. Well, for this matter, the court is not going to stall the selection process. You could have raised this issue before the regular bench.
Well, I have raised, my lord. This was running in the urgent motion list. My lord, this could not be taken up.
And it's an urgent matter. This has to be taken up before 23rd.
Because my lord, interview is going on. And in Bengali,
and a bench which is not in the regular determination will determine the correctness of answer key before 23rd of December and permit you to participate in the selection process. You are not a newcomer in the profession. Yes. Tell what is the urgency. Tell me.
The Bengali, my lord, the interview process is over during pendency of the writ petition.
Which page?
Page 52. The first page of question booklet.
Page 52
is the first page of the question booklet.
53, not 52.
53.
Which question?
Question number 23. Question number 23 and question number 40, my lord, appearing at 56 and 57.
What are the issues?
My lord, in this matter, my lord, two possible answers, my lord. They have chosen one. We are saying that both answers have been correct.
Answer key. Issue is related to correctness of answer.
Answer key.
In both the matters.
Both the matters.
পিটিশনার্স করবে, দুজন পিটিশনার আছে। আচ্ছা, ওটাকে সাজিয়ে নেবে। কোশ্চেন বুকলেট সিরিজ ডি, বেঙ্গলি, 11 and 12। যেখানটা অ্যাকর্ডিংলি নাকি যেখান থেকে চেঞ্জ করে দিচ্ছে প্রত্যেকটা ম্যাটারে বলো তো। এটা একই হবে। হাওয়েভার দেখো তো, কোয়েশ্চেন নাম্বার 23 and 40 of question booklet series D, Bengali. না, তারপর করে নাও, Petitioners have opted on it. না, হ্যাঁ, same.
Obliged, my lord. I'm grateful.
হ্যাঁ, বেঙ্গলি সব কটা। এটা বেঙ্গলি ছিল। দেখি এক মিনিট, দেখি কি সাবজেক্ট ছিল।
Bengali, my lord.
11-12 Bengal.
স্টেট লেভেল সিলেকশন টেস্ট করো কিন্তু 2025। না, বেঙ্গলি বলে বা ব্র্যাকেট করে দিও, তাহলে মেক্স সেন্স।
Item number 8.
Yes.
My application.
But both is challenging the grievance.
His application permit him to make submission. Yes.
The petitioner number 1 is a student who is going to appearing in the Madhyamik examination 2026.
26.
But the last date for form fill up of 13 December 2025. But the
18 December.
13th December.
30th December.
Sorry, 19th December.
19 December.
December
Yes.
2020. But the registration number has yet not been obtained by the petitioner number 1. As such, he came before your lordship. But the kindly come to the page 23.
But copy not served.
There is an urgency.
Yes, but copy not served, my lord. I don't have an instruction. What is the matter about? That was the I was submitting. Let him serve a copy upon me. Let me come back on Friday.
Tomorrow, not
But
Friday.
tomorrow and day after tomorrow, I'll not be.
Then
Friday, your lordship.
no. Then Friday I take up application. Sorry. Tomorrow.
If, my lord, if the you lordship.
Or you obtain instruction, come at 2. Today 2.
Lordship.
Give a copy here and now.
Lordship.
Obtain instruction, come at 2.
Lordship.
Passover at 2 p.m.
Lordship.
Item number 9.
For the petition in this matter, my lord, what happened? The
Just a minute,
my lord.
Representing Miss Bhattacharya, try to obtain instruction by 2. If it is not possible, then I will take up at 2, otherwise 3. Within that time, you take instruction because main grievance is against the board. Yes. Yes, Mr. Ghosh.
Here, what happened, my lord? The husband of the petitioner was an employee of my lord NTPC. Now, my lord, after the death, I have sought for my being the widow of the deceased employee, sought for the all.
Just a minute, let me go
My
to my own
My
order pay dated 12 November 2025. Yes, my lord.
Yeah, I need to push, okay?
Yes, report. What is the stand of NTPC?
But there is a petition pending for grant of letter of administration at the behest of the son from the first marriage. Now, there are two dues which can be.
But so far family pension is concerned, the son is not not entitled.
There are two dues which can be released. Please come to page 4. I have detailed the heads of
Page
dues.
4.
Page 4 of the report.
Paragraph 10.
Paragraph 10. Now, Lordship may straightway come to paragraph 18 at page 5.
Just a minute. Leave encashment, NTPC take scheme, group insurance.
It's not a pensionable service otherwise.
Self-contribution. The self-contributory superannuation pension is there.
It's not a pensionable service otherwise. Now, these are not. Please come to paragraph 18 at page 5.
Page
5, paragraph 18.
Paragraph 18.
My lord. The company can start the medical benefits admissible under the NTPC Limited post-retirement medical scheme to the petitioner. Resultantly, she will be entitled to IPT and OPD medical benefits. Now, she has to fill up a form and submit with us. Furthermore, this amount of 38.86 lakhs is lying to the credit of the deceased employee in the NTPC defined contribution pension trust as on 31st March 25. The same amount can be transmitted to LIC, who will disburse it to her on the basis of her option exercised. She can get it monthly or in a lump sum basis.
Facilities. So it is the claim. So far, this pension through LIC, that is petitioner is solely
yes, she has
eligible.
to apply to LIC because she has to opt for she has to exercise an option. She can either take it in one go.
What is the present position regarding payment of other benefits as indicated in paragraph 10?
But please come to page 14. No, these are the nomination form. I have prepared in the form of a chart. Provident fund 34 lakhs. No, it's 3 crores 41 lakhs 20,000 and odd. But the nomination is in favor of 3 persons. The relationship is like that: 50, 10, 40%.
Who are these persons?
But one is elder brother, sister-in-law, sister. Of course, they hold as trustees for the beneficiaries, but not because of the
elder brother, sister-in-law, sister. Why nomination was not made in favor of the petitioner or the son in the first wedlock?
It appears that after the second marriage, he had only changed the nomination in respect of the defined pensions.
He had only
changed the nomination in respect of the pension scheme and nothing else.
But all these records are of, my lord, at the initial stage of employment of the husband. Now, my lord, thing is, my lord, my lord.
No, if nomination is there, then the employer has to go by nomination.
My lord, I have, my lord, the succession certificate. They have sought for the succession certificate. I have obtained the succession certificate.
Succession certificate, but if nomination is there, how the nomination can be ignored?
My lord, the nomination will, my lord, has, my lord, no effect when the succession certificate is there. Because they sought for, my lord, they intimated me that I should file
serial numbers 1, 2, 3, and 4, as also 5, probably. Up to 6, but these form part of that application for grant of letter of administration, where we are parties.
Yes. They have not challenged that.
No, letter of administration.
It depends upon grant of letter of administration.
Yes.
Now, if succession certificate is obtained, then what is the necessity of obtaining letter of administration?
There's the first son.
But in succession certificate, that
first son is also entitled legally. My lord, first son has applied for grant of letter of administration.
Administration at my lord Delhi, and the cause of action is here.
That
Now,
she has
my lord, there
also
was
furnished a
no order, my lord, from there.
certificate.
Whether the first son is party?
Yes, in this matter, my lord,
Whether
he is
Whether
party.
copy has been served upon
Yes,
first son?
yes, my lord.
Then
I have served.
if first son appears before this court, then court can understand what is the stand of
Yes.
first son. But if there is no letter
This
of
can
administration
probably
for
be
an
obviated.
indefinite period, there is no letter of
This can
administration.
probably be obviated not in the presence of them, not insofar as the other dues are concerned. He has an equal right to the estate of the deceased. But if he agrees not, it can be. But subject
So
not
for that
we are only
pension
holding it for that.
Pension through LIC.
Pension through LIC, she is the sole
solely
beneficiary, sole beneficiary, and the medical benefits.
And other
It's
benefits,
unlimited.
other benefits, my lord, at least 50% at this stage I am entitled.
No. Let me hear the son first.
Yes, my lord. Kindly hear, my lord. I will serve another notice if your lordship is direct, my lord.
If there is an agreement, things can be obviated. All the disputes will come to a settlement.
If first son can be heard, then in that
Yes,
event,
not
then
before I
appropriate order
believe
can
not
be
this can.
passed.
We are holding it with not its accruing interest. Not we are holding it in trust.
Response number 8.
Yes.
Show me how you have served.
Through post, my lord. There.
Only knock. Four 928.
928.
Just
my lord. 928. Yes, my lord. Last annexure.
Old service, 14th May.
Yes.
You have to serve it again because there is a change of determination.
Yes, I will serve. I will serve. By this time, my lord, let them, my lord, disburse the admitted dues.
No, she has to apply with exercise of option.
Yes, I will. My lord, direct, my lord, I will.
She can apply for commutation. She can apply for one lump sum.
Come to page 14.
My lord.
So NTPC self-contributory superannuation pension petitioner is entitled. And what are the other benefits petitioner is solely entitled?
No, NTPC defined contribution pension scheme. That's the
now in this chart at page 14.
Yes.
Serial number 3 NTPC death relief scheme.
Yes.
It comes under serial number 5 under paragraph 10. Provident fund gratuity not solely entitled.
Yes. Provident
NTPC death relief scheme.
The death relief scheme will be paid in lump. But this probably comes under.
I am telling it considering your considering
two, serial number 2.
Paragraph 10
serial number
and
2.
14.
Paragraph number 10, serial number 2.
NTPC death relief scheme. Whether the petitioner is solely.
But there the nominee is elder brother and niece. Should not have been.
Not at this stage, at least. Then, in that event, NTPC self-contributed superannuation pension.
Not last entry, serial number 9, she can instantly withdraw. And she can apply for obtention of the medical benefits.
So, NTPC defined contributions pension scheme.
Yes. There also not, there is a separate nominee.
And what is NTPC self-contributed superannuation pension?
Not,
elder brother is
a nominee.
Here, wife is the nominee.
Here, she is the nominee.
That's why you are submitting.
Serial number 9. And that
which is defined as serial number under serial number 6 in paragraph 10.
Yes.
Very well. In the meantime, I will direct the concerned authority of NTPC to release NTPC defined contribution pension scheme by transmitting the amount to LIC. And on completion of necessary formalities, the benefit under such schemes should be extended to.
And she can additionally apply for the medical benefits, both OPD and IPD.
That is unlimited.
which is unlimited.
My lord, that may also be
Apply
issue. In terms of previous order, a report in the form of affidavit affirmed on 11 December 2025.
But I should also point out, not in
On
paragraph
behalf-
5,
just a minute.
there is
On
an
behalf
error.
of, on behalf of National Thermal Power Corporation,
NTPC Limited. It's NTPC.
NTPC Limited, on behalf of NTPC Limited. সেন্টেন্সটা বড় থাকবে।
এটা কি হবে বলো তো এটা? এটা কি হবে?
Elder brother হবে।
Is filed today and same is taken on record. Yes, what you are submitting?
In paragraph 5, not there is an error, not apropos page 14.
Paragraph 5.
Yes, at page 2.
Yes.
It's not mother, sister, and brother. As in page 14, it is actually elder brother, sister, and sister-in-law. And the ratio is 50, 40, and 10.
There was a sister and sister-in-law.
Yes.
Yes, that is apparent from page 14.
Page 14.
You will indicate on the next. Stop. As per report and the submission made by Mr. Mojumdar, learned senior advocate representing NTPC Limited, it appears petitioner being
And niece.
wife of the deceased employee is entitled to get benefits under NTPC defined contribution pension scheme. It is submitted in respect of other benefits as delineated in paragraph 10 of the report filed today. Petitioner is not the nominee. Therefore, claim of others, if any, needs to be considered. Needs to be considered against those benefits. Next paragraph. Today, son of the deceased employee born out of first wedlock or born in first wedlock, being respondent number 8, is not represented in spite of service of notice. Stop. Next paragraph. Learned advocate representing the petitioner is directed to serve notice upon respondent number 8 enclosing copy of this order by fortnight from date and file affidavit of service on the next date. Stop. List the matter under the same heading for further consideration on 15 January 2026. Next paragraph. Meanwhile, concerned authority of NTPC Limited is directed to transmit the amount payable to the petitioner under NTPC defined contributions pension scheme to the Life Insurance Corporation and said benefits shall be released in favor of the petitioner on compliance of necessary formalities by 4 weeks from date. Stop. Next paragraph. In addition thereto, it is submitted on behalf of NTPC Limited that petitioner is entitled to receive benefits under the medical what medical scheme.
Medical, it's called NTPC Post-Retirement Medical Scheme.
NTPC post-retirement medical scheme. Stop. In the event of requirement, it is directed that on making appropriate application, benefit under post-retirement medical scheme shall be extended to the petitioner.
In the meantime, may I file my exception to this report?
Yes, file an exception. A petitioner shall also be at leave to file an affidavit taking exception to the report filed today on behalf of NTPC Limited by fortnight from today, or by 1 week after ensuing Christmas vacation.
Good.
Next.
Item number 10.
For the petition.
My lord, I am for the respondent, my lord.
Just a minute.
My lord. Kalam na.
Yes, affidavit service.
Has been handed over.
Who is appearing for the state? Serve notice upon Mr. Tapan Kumar Mukherjee. Because state has to be heard. Your contention is that you are not the
Not the
same person.
Yes. Imam Haq
Imam Haq or Imam Hussain is a different person.
separately different person.
So therefore, court wants the stand of the state, and on what basis petitioner was considered to be a person implicated in the criminal proceedings, being Manik Chowk PS case number so and so.
There are two documents. One document says that there is no antecedents against me, and another document says there is antecedent giving 6 names against me without the father's name. So that is absolutely incorrect. Cannot be. To different person, I have been dismissed from service, and I have all the documents to show from the court records and everything.
You have made necessary amendment in the cost title.
My lord, no copy was served upon us, my lord.
It's not required at this stage.
My lord, on the last occasion, your lordship
Let
was
me
passed
see.
an order there.
Amended.
Affidavit of service filed on
Only amended cost item.
Only amended cost item.
serve an amended cost title. Serve an amended cost title. Since it has been amended, they are entitled to get the amended cost title of the writ petition.
But I'm told that this Joita Sinha is appearing on behalf of the state.
Where is she?
It's some another court. She's on her legs. Yesterday also time was taken on the ground of this.
No. It was we who took the.
So on the state authorities, I mean to say.
I'm not talking about state.
Have you served the GP office?
Sir, not today.
Not today.
Take it back.
Great.
Item number 11.
Dear my lord, I am for the petition.
I'm for the union.
What is the matter about?
Yes, my lord. The petitioner, my lord, was working as constable in BSF from since this December, my lord. He just retired in 1990.
When he retired?
Since, my lord, with effect from this December.
He will retire.
He has retired. This is the December. So he has retired from first.
From which date? What is the date of
First December of 2020. So last day of the November was his last date of service.
Say so. Yes. Then what happened?
In Milord 1992, when he was on duty, posted in Milord Kashmir, the extremist Milord attack, and he suffered bullet and sharp nail injuries. Now, since 1992, he is 100% disabled in his lower body, Milord. Now, in this case, Milord, since 1990, there are several notifications that if a military or paramilitary person suffers Milord injury while on duty, then he Milord gets Milord ex gratia grant. In this case, Milord, that has not been done.
So that ex gratia is payable on retirement?
No. At the time of Milord, he suffered his loss. Immediately thereafter, it is up to the BSF to communicate with the concerned state. In my case, it is state of.
So if this incident of bullet injury took place in 1992, so from 1992 to 2025, what you are doing?
I have, Milord, my respectful submission is I have no role to play in here.
But if it is your right to get the benefit, and if it is not paid, is it not your duty to claim the said benefit?
That, I have already claimed. So on the basis of that,
no, for 37 years you have not claimed.
Because, Milord, the matter is, Milord, what are payable, Milord, that is not clear to the Milord concerned, Milord, the employee.
The benefit which is payable to an employee or a member of a disciplined force, if the same benefit is not paid wrongly, then it is the duty of the incumbent to lodge claim against payment of such benefit.
Then, Milord, here something more, Milord, happened. What happened, Milord? They initially terminated me from the service. Now I, Milord, preferred a writ petition before the Honorable Jharkhand High Court. My writ petition was dismissed, and I have annexed already, Milord, the order. And in appeal, my appeal was allowed. So in the appeal, the Honorable Division Bench of Jharkhand says all the dues, all the benefits should be, Milord, payable to me. But in spite of that order, Milord, in spite of the direction upon the union, that has not been done paid to me.
Yes. Why ex gratia is not paid?
My lord, this is the report, my lord.
Tell me why it is not paid.
My lord, he has been paid, my lord. My lord, this is the report, my lord. My lord, my lord, kindly come to paragraph D, my lord. This was the reply.
that he was paid, my lord, 10,85,508 as capitalized value for disability on March so and so.
Which paragraph?
Paragraph D, my lord. Well, ex gratia amounting rupees 5,000 was already paid by Jammu and Kashmir, stands paid to you on 96, my lord.
So, petitioner was entitled to get ex gratia of 5,000.
My lord, there is a certain, my lord, there is a chart, my lord.
That chart is
Accordingly,
on page 35.
Page
35 of the report.
my lord, this page 35.
Just a minute.
My lord.
So you are coming under which head?
I am coming under, my lord,
Page
permanent
35?
disability. Permanent disability, that is
Partial disability?
permanent disability. That is third point, my lord.
0.75 lakhs.
75,000.
75,000.
My lord, will kindly see the date of this circular, my lord, he's relying upon. My lord, this GO was in 2024, my lord. So my lord, 1, 2.
So tell me what was the GO which was applicable at the material point of
My lord,
time when the incident took place?
my lord,
When
there are
the incident of injury occurred?
that I have asked, my lord, the department to send that circular, my lord. I have also asked that.
Why
But
5,000? Very well, 75,000 is not payable.
that since
This is a government order, this payment needs to be made in terms of the relevant government order, and this government order at page 35 is dated 14th November 2024.
and my lord,
When the incident took place in 1992. But what was the government
my lord,
order prevalent at the
I have
material point
asked
of
them,
time?
since they have not given, I have asked the department to produce, my lord, give that, my lord. Will give with regard to that, if your lordship gives me 1 week time, my lord, so that I can take instruction with regard to that.
And my lord,
But this matter was twice adjourned.
My
On
lord,
your,
they have given this, my
on
lord,
your
so
prayer.
far, my lord, so far, my lord, they have given this instructions with that since he was paid, my lord, 5,000. They said, my lord, so he is not entitled. And furthermore, my lord, I have shown you that paragraph D, my lord, that he was paid 10,85,000, my lord.
Yes, that I've seen 10,85,000 as capitalized value for disability on 4th March 2005.
My lord, so far the instruction goes, my lord, that they say that since this both has been paid to him, he's not entitled to. This is, and further, my lord, which has fallen from your lordship.
He is also questioning the quantification. Based on this memo dated 14 November 2020.
My lord, this
he is saying the amount which was paid is less than the amount which was liable to be paid by the department.
My lord, this amount was paid in the year 2025, my lord.
Yes.
He keeps silent for around 20 years.
But if it is paid to him, it's a continuous cause of action.
My lord, but since he was reinstated, my lord, it was not that he was initially terminated, his service was terminated, but subsequent to he has been reinstated, my lord. With regard to this, is the so far the instruction goes like this, my lord. I have asked them to provide that chart under which they have given this.
Yes, if more is required to be paid in terms of
My
the
lord,
position which was prevalent at the time when incident occurred, then petitioner is entitled to get further amount.
And
with regard to that circular, I have asked them to produce that circular.
Petitioner was in BSF.
BSF.
Petitioner was serving in BSF and retired on superannuation on 30 November 2025. Stop. It is next paragraph. It is submitted by the learned advocate representing the petitioner that he suffered bullet injury in 1992. In course of his duty, which makes him entitled to receive ex gratia payment. Stop. According to the petitioner, according to the petitioner, said benefit till date is yet to be paid, or till date is not paid. Next paragraph. Learned advocate representing Union of India has filed a writing dated 5th December 2025 enclosing certain documents and placing reliance upon a document dated 29 December 2006. It is submitted that rupees 5,000 was paid towards ex gratia on 31st May 1996. Stop. Next paragraph. However, quantification of ex gratia amount is questioned by the petitioner on placing reliance, by placing reliance on a government order dated 14 November 2024. And it is contended that in terms of the said government order dated 14 November 2024, since it is a case of permanent disability, due to injury caused to the petitioner, he is entitled to receive rupees 75,000, or he is entitled to receive rupees 0.75 lakhs. Next paragraph. On behalf of Union of India, such claim of the petitioner is disputed, and it is submitted that government order dated 14 November 2024 is not applicable since the incident of injury took place in 1992. Next paragraph. On query being posed to the learned advocate representing the Union of India as to which government order was prevalent at the material point of time relating to payment of ex gratia, accommodation is paid for on behalf of the respondents to produce relevant government order on the next date. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 14 January 2026.
Item number 12.
I am
Appearing for the Union of India. I am paying not this week, man. The petitioner, instead of serving the copy to the Ministry of Law, served the copy to the unit, man. I don't have any copy of the petition.
Serve the copy to unit.
The unit.
Yes, unit are the respondents. You are appearing. Then what is the difficulty?
Copy not yet received, my lord. I'm paying a not this week. Yesterday, my lord, the unit received the copy, my lord.
So you are required to serve upon the branch secretariat, Ministry of Law and Justice, Kolkata.
I have served upon the commandant of the.
In addition thereto, you are required to serve upon Ministry of Law and Justice.
On the last occasion, your lordship advised me to serve upon the Ministry of Law and.
Well, no copy was served to the Ministry of Law.
Show me that you have served upon the Ministry of Law.
Ministry of Law and Justice.
Show me. Learned government pleader it is addressed to.
Ministry of Law and Justice.
What is your notice? Why learned government pleader? Whether state government is a state respondents of the parties?
No, the parties are CISF, Shalboni, Delhi headquarters.
Malad, Union of India is not yet party, man.
Show me that you have served upon Ministry of Law and Justice. On the contrary, your notice is addressed to learned government.
For Branch Secretariat, Ministry of Law and Justice, Stand Road. The fourth one.
Where is the service?
These are the tracking reports I annexed. The tracking reports of all the four are the tracking reports, the track reports. I have annexed all the tracking reports, Your Lordship.
Yes, show me that it has been served upon Ministry of Law in the simple thing.
Item 486. Your Lordship, this last one, 486 IN, item delivered. It is showing. The last one, consignment tracking report, consignment number EW 486 IN, item delivered. It is the master. Sure. My client has been suffering since 1 year. He's
Just a
suffering
minute.
serious ailments. He can't stand properly, can walk.
If your writ petition is not ready for hearing, how court will hear it?
I have served upon the CISF Shalboni, I have upon the DIG Delhi and the branch secretary of the Stand Road, branch secretary. Yes, for your instruction, Your Lordship, on the last occasion.
My lord, Union of India is not a party in this case.
Yes, branch secretariat was served on 15 December 2025. 15 December, 48 hours is not over. Today we are on 16 December.
This just been served, Your Lordship. But Your Lordship, just one thing I need.
Are you aware of the procedure of or writ rules?
Normally, a reasonable time should be given to the opposite.
48 hours.
48 hours.
But it is
Your
not
Lordship,
over. And he is saying that he is without any instruction and there is no service. You have to wait for some time. Esho.
Your Lordship, just one thing I need to mention. Just one.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Blind advocate representing Union of India has paid for accommodation to obtain instructions. List the matter under the same heading for further consideration on Monday next, 22nd December 2025.
Your Lordship,
Next.
Your Lordship, that's one thing, Your Lordship. The respondents are mixing the professional life and personal life of the petitioner, and they are not paying the pension.
So you will make submission on the next date.
Item number 13.
My lord, I am appearing on virtual mode.
13 and 14, I am led in this matter by learned
my lord, I am appearing virtual mode, my lord. I couldn't take the flight whole night. I was stranded on the airport. All flights have been cancelled, my lord. I'm trying to come to Calcutta anyhow, my lord, somehow by going to Mumbai or Jaipur. But kindly accommodate me for 2 days, my lord. Because, my lord, I don't know whether I'll be able to take the flight today or not. For this reason, my lord. Day after tomorrow,
now you are in Delhi.
Yes, my lord, I have no other option but to be in Delhi. Kindly take it. Petitioner will not suffer, my lord, anything. It is a non-cumulative
You have
punishment.
to show, my lord, only the supply of the inquiry report upon my
My lord,
case.
I will show everything, my lord. I will place the rules, everything, my lord. Kindly take it up day
This
after
question
tomorrow.
was
I'll do
put by
it.
your lordship on the last occasion. That without
I'm
supplying
without
the
my
inquiry
papers, my
When you are
lord.
coming back?
My lord, I'm trying to get the flight tickets even by paying 50,000, my lord. But I'm not getting it. My lord, whole night I was at airport, my lord, stranded. I'm again now going to airport to take any flight, whatever is available, either from Mumbai to or from Jaipur. Delhi situation is very bad, equine. No flights are operating.
Due to fog.
Due to fog. AQI is 700 over here. So I'm traveling to Jaipur and from there I'll take a flight to Kolkata.
Let it be on 18th. Let me see. 18th. Today is 16th. Thursday. Let me see, Miss.
I understood, my lord. I have also faced this situation on the last week, my lord.
Yes.
But my lord, my difficulty, my lord, 18th and 19th, my lord, if your lordship kindly consider tomorrow, my lord, it would be better, my lord.
My lord, tomorrow I cannot say if I'm not able to.
He is in difficulty.
I understood, my lord. On the last
18th, 19th, my lord, then can it be on 22nd?
What is the urgency? It says the last.
Yesterday, my lord, they have prayed, my lord.
Yes, I have expressed my mind. That is that's why it is urgent.
No,
but
not
so far
urgent,
other thing is concerned.
No,
that is this is the order passed by the revision authority on 24th of May 2025.
I understood, my lord. But one question that they need to answer: the whether supply of the inquiry was made.
May it be taken up on 22nd Monday, because he's in
several other matters are fixed.
On
it's up to the convenience of the court.
Thursday, because on Friday applications are taken up.
My lord.
Let me
Grateful.
See. Let me see.
Deeply obliged.
Thursday, actually,
Yes.
Matter is
My lord, if he is in difficulty, my lord,
Central
can he be
Administrative
on
Tribunal.
reopening date?
One matter is
So if you are not able
after
to
vacation.
appear,
Online, my lord,
send
can I
any of
virtual,
your
my
junior or any friend, I will accommodate.
But
Let
if
him
I
retain his
appear
position in-
virtually, my lord, if I
Yes, yes, you can.
oblige, my lord, from there, my lord, oblige.
Deeply
13 and 14 both.
Yes, 13 and 14 on Thursday.
Grateful to your lunch.
Deeply obliged.
Item number 15. My lord, I am for the state.
Just a minute.
My lord, I am for the state.
Yes. But last occasion, yesterday also time was
Lordship,
taken.
Lordship.
No short passover is not possible in all matters. Yesterday, I adjourned this matter. Every day is the same treatment. What is the matter about Mr.
My lord, the report has been submitted by the department, my lord. Lordship, kindly see.
These are civic volunteers, my lord. There is a criminal case, my lord, pending against them, my lord. The guidelines, my lord, which, my lord, guides their employment says, my lord, if there is a pending criminal case, my lord, till such pendency, my lord, they will not be given any work.
Lordship.
They prefer an appeal before the apex committee, my lord. The apex committee has said that the moment the criminal case is quashed, we will give you appointment. But till such time, we will not give any benefit to you. We will not be remobilized. And that is the thing of the matter.
My lord, Geo is there also, annexure 6. There it is specifically mentioned. হ্যাঁ হ্যাঁ রিপোর্টের কপি আছে তোমার কাছে আচ্ছা
So demobilization order is under challenge.
Yes.
Now the ground is pendency of the criminal proceeding.
Lordship.
So according, is there any rule that if the criminal proceeding is pending, that petitioner will not be given any allotted any will not be allotted any work?
Annexure 6, my lord, in the report.
So according to this demobilization order is passed in terms of this guideline.
Lordship.
Issue. At the time of call, accommodation is paid for on behalf of the petitioner. However, state respondents and Union of India.
No statement. It's item number 17.
Oh,
Yes.
I am in
Civic
16.
volunteers, my lord.
I am in 16. Our state respondents, your state respondents are represented by learned advocate. Stop hearing of this matter stands adjourned. List the matter under the heading motion in the monthly combined list of January 2026. Take it back. Lordship. Next.
Same as 15, my lord. 15 to 18, same as.
I'm told 15 to 18 are the same.
Petition order. Same order. Same order. Who is appearing for the petitioner?
Same petitioner, my lord.
Same order. Monthly list of January 2026, 2026. Yes. Next matter.
17, my lord, I approve the state, my lord.
My lord, same matter.
Same.
Yes.
17 is also same.
Same.
दाओ तो देखिए file.
Order under challenge.
Same order.
I'm grateful.
Item number 18.
Same. You are for the state. Same order 18.
Item number 19.
Item number 19, according to the petition, your lordship, it is on the same matter, non-payment of 80% of my provident fund. Here I am paying for 80%.
Lordship, I am for CST.
With interest. That
I have passed an order.
Yes.
passed an order on 8th of December, your lordship. Here, the retirement date is to be changed, and the second one is to change. Your lordship, their prayer is for interest on delayed payment of gratuity, but in this case, there is no delayed payment of gratuity and leave salary. I only am paying for 80% of my
Provident fund.
With interest and 20% of my provident fund. Means
20% interest on 20% as well as 80%.
80%.
There's a delay in releasing
Provident fund only.
provident fund.
Okay. No gratuity, no leave salary.
Calcutta State Transport Corporation. You are representing Calcutta.
Yes, Lordship. I am led by Mr. Bihani.
Where is Mr. Bihani?
Lordship, he is on lakes.
When retired in item number 19?
31st of August 2023. He is under contributory provident fund.
your claim is confined to provident fund, that is 80% of which is remaining unpaid, and the interest on provident fund, that is including 20% and 80%.
Not sure. Not sure.
6 weeks and 3 months.
3 months. Not sure.
80% to be released in favor of the petitioner by 6 weeks, and by 3 months interest. 6% failing which it will carry 8% interest. Disposed. What is the role to be played by the state?
Lordship, actually the role played by the state is that the CSTC has to make a recommendation for fund to.
So any fund is required to be
Yes,
allotted.
yes, Lordship, state is allotted
একটা
fund.
paragraph add করে দেবে তো অন্য ম্যাটারও আমি করে দিচ্ছি। If it is required, state authorities, if it is required, state respondent shall allot necessary fund for releasing benefits in favor of the petitioner as directed by this court. Good. Yes, disposed of next.
Item number 20.
করে দিও পরে।
Item number 20, Your Lordship, I am praying for encashment of my leave salary for 300 days instead of 180 days, Your Lordship. Your Lordship, in this matter, in a similar matter, Your Lordship has passed an order. May I hand over the order?
You are paid for 180 days.
80 days. So I'm
Yes,
praying-
give me the order.
Lordship, this is the order, Your Lordship. The difference is that, Your Lordship, this order and my submission before Your Lordship, the retirement date is to be changed, and my lord has given the liberty to the petitioner to make a representation before the concerned authority, Your Lordship. Your Lordship, in this matter, I have already made a representation. That is
to be considered
Lordship. That is to be
by the general
managing director of the
Managing
Respondent
Director.
Corporation, Your Lordship. You take the service.
Transport, Calcutta State Corporation.
Lordship.
Calcutta State Transport Corporation. When retired?
Lordship retired from 31st of August 2024.
So you are relying upon clause 9 of memo dated 17th September 2009. Who is for the state? State is party.
Yes, Your Lordship. Respondent number 1 and 2.
এই সত্য। আচ্ছা এই প্যারাগ্রাফ কোডটাকে একটু এইভাবে করে দেবে তো চেঞ্জ করে। It is pointed out by the learned advocate representing the petitioner that a representation is made. Where is your representation?
Lordship, page number 21, Anisha People. Representation.
Page
number 21 followed by a reminder.
A representation is made addressed to the managing director of the corporation, being respondent number 5 for enhancement of leave encashment benefits This court finds that such representation needs to be considered by the appropriate authority. এইটাকে চেঞ্জ করে দিলাম, হ্যাঁ, প্যারাগ্রাফ 4 টাকে। Next paragraph, এটাও চেঞ্জ হবে। Response number 5 is directed to take decision on the representation dated 2nd January 2025, claiming leave encashment benefits for further period of 120 days by 8 weeks from the date of communication of this order. Stop. Response number 5 shall pass a reasoned order, and same shall be communicated to the petitioner by 10 days thereafter. Next paragraph. 6 টাকে রেখে দেবে, থাকবে। এগুলো থাকবে 6, 7, 8 সেম ডিসপোজড অফ। আর ডেট অফ রিটায়ারমেন্টটা নোট করে নিয়েছি তো, আমি লিখে দিয়েছি ওখানে। ইয়েস, নেক্সট ম্যাটার।
Item number 21.
Ashu, this is regarding the non-payment of 80% of my provident fund and interest on delayed payment of my gratuity and leave salary. This is the same order. Determine date.
Affidavit of service.
Lordship.
When retired?
Lordship, 31st of May 2024.
2024.
Yes.
Lordship.
Leave salary and gratuity were also paid after belatedly, not within time. And 20% of the provident fund was paid.
Was paid belated.
It is a late payment. It was a late payment. Who is for the state?
I am for the state.
With the stated directionটা করে দিলাম না, ফার্স্ট ম্যাটারটা, ফান্ড ওইটা প্যারাগ্রাফ 8 করে দেবে। Disposed of.
Item 22.
It's also same.
Like the previous matter.
Yes. Date of retirement is 30th of November 2024.
80% provident fund, leave salary and gratuity. Same order, where date of retirement
30th of November 2024.
30th November 2024. Same order.
I'm up to the state.
Item 23.
Item number 23, your lordship, there is difference in that, your lordship. In the earlier two matters, they are covered, the petitions covered under the contributory provident fund. But in this matter, your lordship, the petition is covered under the general provident fund. That's why 50% provident fund was paid to me, and now the due is 50% provident fund. It's my own contribution, general provident.
Only 50% provident fund, nothing else. No interest, nothing.
50% provident fund with interest and interest on delayed payment of my gratuity and leave salary. And the first line should be there, your lordship.
50% PF to be paid.
Yes, your lordship, with interest and
Then interest on provident fund, gratuity and leave salary.
your lordship, date of retirement.
Just a minute.
Lordship.
Retired on,
31st of January 2025.
give me copy of the order.
Lordship, I don't have another.
ওই আগের অর্ডারটা একটা বার করো তো কপি।
Your lordship, one more line is to be added, your lordship, in place of the contributory provident fund, my general provident.
জাস্ট আগের ম্যাটারটা একটা কপি বার করো।
ওই রাজকৃষ্ণ বল্লভ।
রাজকৃষ্ণ বল্লভ ছাড়া আরেকটা আমি অনিমেষ বাসুটা দিয়েছিলাম, যেটা
আচ্ছা,
8 তারিখে অর্ডারটা ছিল।
হ্যাঁ, বুঝতে পেরেছি।
বার করে দিয়েছি।
Calcutta State Transport Corporation.
Yes.
Retired on 31st of January 2025. Not under contributed provident fund, but under general provident. Who is for the state?
I'm for the state.
ওই স্টেটের লাইবিলিটিটা করে দিল, একটা অ্যাড করে দিল। হ্যাঁ, 50% provident fund due was paid to the petitioner within time.
No, belatedly.
So interest on inter-provident fund. Disposed of. Yes, next item.
Item number 24.
This is CPF, contributory provident fund.
Yes, what you are claiming?
Worship 80% provident fund with interest and interest on delayed payment of my gratuity and leave salary.
80% provident fund and 20% provident fund already paid. So 80% and provident gratuity and leave salary.
Salary.
Copy of the order.
Not sure, I don't have.
এই আগেরটা হবে না, দেখো আগেরটা একটা আইটেম নাম্বার 22 টা বার করো, করে ওই অর্ডারটা যেটা এই অঞ্জন, এটা কি নভেম্বরের একটা ক্যালেন্ডার এখানে রাখানো আছে, পুরনো বার নামাও, আর নাহলে ডিসেম্বর করো, আর নাহলে নামাও। Retired on
31st of December 2024.
your claim is 80% provident fund.
Not sure.
Interest on entire amount.
Entire amount.
Interest on all the dues. 31st December 2024.
Yes.
No, that is not the matter. It is on leave salary 300 days vis-a-vis 180 days.
Number 24.
Find out which one is the correct item.
Number 24, Nikhil Chandra Roy.
24. Previous matter, which matter is covered so far this matter is concerned.
22, your lordship.
22 is a different matter. It is 300 days and 180 days leave salary.
No, your lordship. Bablu Das, item number 22 is the CPF matter, your lordship. Your lordship, 300 days is item number 20. Gautam Das and Gupta.
Bablu.
And I'm relying on
Hey,
item
এটা নয়
22.
বাবলু দেখ হবে না, অ্যাডজাস্ট রাখো, যদি পরে ওর অনেকগুলো ম্যাটার আছে।
21 টা দেখো।
23. On his password.
হ্যাঁ, similar আছে।
এটা বার করলে হবে।
ওটা রেখো না, ওখানে কনফিউশন হবে। ওই কপিটা আমায় দিয়ে দাও, যেটা আমি এক্ষুনি করলাম লাগবে না, ওটা আমায় দাও, তুমি ওটা কারেক্ট কপিটা বার করো। বাবলু দাস, বাবলু দাসের মধ্যে যে অর্ডারটা আছে রিলাই করেছে, সেই অর্ডারের বার করে ওর একটা কপি বার করে আবার বাবলু দাসে ওই অর্ডারটা দিয়ে রেখে দিতে হবে। 22। আমায় দেখিয়ে নাও একবার, বেটার। এটা বার করো, করে এটাকে জায়গায় রেখে দেবে। ও, You are for the state.
My lord,
স্টেটের পার্টটা প্যারাগ্রাফ 8 এ ইনসার্ট করে দেবে, হ্যাঁ? ডিসপোজড অফ।
Item number 25.
Is as item number 23. She is
23.
covered under GPF. So 50% provident fund is due.
23 একটা কপি বার করো। When retired?
She retired from service on 31st of January 2025.
Under the General Provident Fund scheme. So 50% you are claiming 50% of PF
Yes.
and interest on
interest.
entire PF, gratuity and leave
Yes,
salary.
sir.
ছেড়ে দাও, ওকে ছেড়ে দাও, লাগবে না। তুমি শুধু স্টেটের ওই যে ডিরেকশনটা ওকে একটু বলে দিয়ে দাও, লিখে নিক। Kate, you are appearing.
ওকে দিয়ে দেবে 26 থেকে রণজিৎ দিয়ে দেবে। দিলাম।
এসো, এইখানে ওই যে স্টেটের ডিরেকশনটা যেটা ওকে বলে দিয়েছে তোমাকে, হ্যাঁ, ওইটা প্যারাগ্রাফ 8 এ হবে। আর অরিজিনাল প্যারাগ্রাফ 8টা 9, 10 হয়ে যাবে, ঠিক আছে? আর এইখানে দেখবে 20%টা 50% হবে, 50-50 লেখা আছে। জেনারেল প্রভিডেন্ট ফান্ড 50%, 31st January 2025 রিটায়ারমেন্ট, এটাকে ফলো করে দেবে, দেখে নাও। নেক্সট,
26 থেকে রওনা দিচ্ছি।
Item number 26.
27 is the same as item number 24, contributory provident fund, CPF, 80% provident fund. At 24.
Contributed provident fund.
Lordship.
So you are seeking 80% PF and interest on provident fund gratuity. Which item is similar?
24.
এই 24 থেকে ওটা বার করে দাও। When retired?
Lordship, he retired from service on 31st of January 2024.
হ্যাঁ হ্যাঁ। Under General Provident Fund scheme. Yes.
Unless CPF.
Under CPF.
CPF. So 80% provident fund with interest.
Contributed provident, 80% and the interest on entire amount.
Entire. Lordship.
You are for the state.
Lordship.
Ranjit. এটা ডেট অফ রিটায়ারমেন্টটা চেঞ্জ হচ্ছে, যা আছে তাই। এইখানে স্টেটের যেটা ডিরেকশন হচ্ছে স্টেটের উপর প্যারাগ্রাফ 8 ওটা ইনসার্ট হচ্ছে করে 9, 10 প্যারাগ্রাফ করে 8টা 9, 9টা 10 হয়ে যাচ্ছে। Yes, dispose the.
Item number 27.
I am for the statement.
It is the same as earlier one, CPF.
Just previous one.
Just previous one.
একটা কপি বার করে দাও। Retired on?
Retired on 30th of September 2024.
Under contributory problem. So you are seeking 80% of PF.
And interest on total terminated.
You are for the state. Stated paragraph easily disposed of.
Gratefully.
Yes, grateful. Next.
Item number 28.
28, may I please, Your Lordship, I am for the petition. This is my affidavit. But my candidature has been rejected on the ground of, kindly come to page 32. First page 20. 20 of my writ application. Varicose vein, right leg. Thereafter, I preferred review medical examination. The review medical examination board sent me to for some ultrasonography, color Doppler, and another test also. Kindly come to, and the specialist opinion. Kindly come to page.
Page 22. Where is the review report?
Yes, page,
Review is at page 32, my lord.
Page 32.
32, my lord.
Page 32 is the review medical board decision. Here, due to extension deformity present at the left elbow joint, different. Prior to that, they have reviewed medical board send me for the specialist opinion and the X-ray. Kindly come to page 30.
Just a minute.
Varicose vein I found fit after color Doppler test.
No, review report page 32. Reason for medical unfitness views on a varicose vein right leg.
Yes, that has been referred for the purpose of review. And the 3B unfit on account of 3B clause 3B unfit and different. Unfit due to in varicose vein I found fit.
File a report disclosing that why
I'll
petitioner
file
in the review was declared unfit.
Kindly come to page specialist opinion.
Yes, that will be considered later on. Filed your affidavit of service. filed on behalf-
Even a joint deformity, my lord, is within the
File a report
and I'll file it.
disclosing the reason for declaring the petitioner unfit on review. Your file your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Stop. Grievance of the petitioner is in medical examination, petitioner was declared unfit. Stop. Petitioner preferred review, and in review medical examination also, petitioner was declared unfit, and review medical report dated 27 November 2025. Page 32.
32 is 27th November
27 November 2025, and review medical report dated 27 November 2025 is questioned. Next paragraph. Union of India is represented by learned advocate. Stop. Concerned authority, concerned respondent authority is directed to file a report in the form of affidavit disclosing the reasons to declare the petitioner medically unfit by 2 weeks or by 1 week after ensuing Christmas vacation. Stop. List the matter under the same heading for further consideration on 19 January 2026. Next.
The interim protection.
What protection? At this stage, no protection.
Because this is
You have participated in the interview medical test.
May I prefer one thing, I think the number which has been indicated in the cost title is different from this sheet application. What number? Oh, then I shall correct it in the service. Kindly give a link to it.
Correct it.
Much obliged.
ওটা correction করে তখন নেবে correction করে দিই তখন yes next matter.
Item number 29.
Lordship, I'm appealing for the petition. Lordship, here my prayer is for refund of an amount of rupees 93,486, which has been recovered from my terminal benefits, my leave salary. They have recovered an amount of rupees 93,000 and not from my leave salary. I'm a retired employee of the Calcutta State Transport Corporation, and the pay slip for the month of November says that I'm entitled to get the earned leave for 62 days, which amounts to rupees 1,25,000. But while disbursing my terminal benefits, Your Lordship, they have disbursed an amount of rupees 31,000 and odd towards my leave salary, recovering an amount of rupees 93,000 and odd.
Yes, where is that recovery order?
Lordship,
Where is the recovery order?
Lordship, there is no recovery order, Your Lordship.
So which document demonstrate that there was a recovery?
P2 at page number 12, Your Lordship, kindly see. Page number 12, annexure P2. If my lord, this is the pay slip. Your Lordship will come to the extreme right, deduction. Over the head is deduction, and the amount, Your Lordship, kindly see the earned leave, the last line. Extreme right, last line.
Where is earned leave?
Earned leave, EL. Extreme right, last line. Earned leave, 62.726063. Yes, 62 days earned leave. And this column.
Yes, last line within the table, earned leave 62.726063.
It is 62 days. 62 earned leave, they have deducted because it comes under the heading, Your Lordship, deduction. So this is my whole prayer before Your Lordship.
What is the date of this document? What is the date of this document?
Payslip for the month of November 2023.
So why you are coming now after 2 years?
Lordship, I have been paid my provident fund and the gratuity only after this contempt application has been preferred before this honorable court for payment of my term is my provident fund, Your Lordship. And I have been paid my leave salary belatedly. I made a representation to them for payment of my this amount, refund of this amount from which has been recovered from the terminal benefits. But this represent did not yield any result, Your Lordship.
What was the decision taken on the representation? What was the decision taken on the representation?
Nothing, Your Lordship.
So let the representation be considered, claiming refund.
Lordship, in the light of the judgment passed by the Honorable Supreme Court in Rafiq Masih's case, Your Lordship, they cannot recover this amount as per paragraph 18 of the judgment, Your Lordship. That the terminal benefits, the earned leave is my terminal benefits, Your Lordship. So they cannot recover this amount from my terminal benefits.
In that event, why you have not approached this court just on the next date of your retirement or November or in the month of December 2023?
Lordship, at that point of time, I was not paid my leave salary. I was paid my leave salary in mid of 2024, Your Lordship. It has been paid. And in the month of November, I was paid my 80% of my provident fund in terms of the order of this honorable court, Your Lordship. So, Your Lordship, that is the whole problem, Your Lordship, because I have been paid belatedly.
So, did you file a writ petition? Did you file a writ petition subsequently for payment 80% of provident fund?
It's been paid.
No. Did you file a writ petition or it was paid in its usual course?
No. Yeah, I prefer a writ petition before this honorable court for payment of my.
When you preferred writ petition?
Lordship, it was in 2025, Your Lordship.
So why you did not lay claim?
For recovery of this amount.
Yes.
Your Lordship, at that point it is not evident.
Why? It's a leave salary. It's a pay slip for November 2023.
Lordship, I did not raise this issue. It is admitted fact.
Then-
Because I approached them, they said no because they do not usually.
Show me that writ petition.
The writ petition is for payment of my 80%.
Yes, show me that writ petition. Let me see what was the prayer couched in that writ petition.
Well, I don't have it because they did not appear in that writ petition.
Yes.
So I would have brought.
Produce that writ petition.
Well, only one more thing. Not
Because it was open to you to claim this benefit, this refund while filing the writ petition.
That was not.
You did not lay any claim. You did not make any claim. Now you are hit by explanation 4 of section 11 of CPC, constructive res judicata,
Your Lordship, that was not so, Your Lordship.
which was at the point which was available to you to agitate. In that writ petition, you did not raise this point.
Lordship, may I submit one thing, Your Lordship? I made this writ petition for payment of 80% of my provident fund and interest on the delayed payment of my gratuity and leave salary. This admitted one, Your Lordship. Because prior to getting of my 80% of provident fund in terms of the order passed by this honorable court, I was paid my leave salary. It is admitted, Your Lordship. My learned senior friend is appearing. Lordship, I have been paid my leave salary. And I made a representation. I went to them saying that how much it is available to me. Because
Where is your representation?
Lordship, next page P4, P3, page 13. This is my representation.
18 November.
Lordship, it is. Lordship, I admit it, Your Lordship. The writ petition is for non-payment of 80% of my provident fund and interest on delayed.
No, why at this stage you did not claimed this refund?
No, sure. I did not claim. This is the first time I'm praying for refund of this amount. That is admitted, Your Lordship. Because I was not in that position to claim that, and it was at 62 days leave. I do not know how much is the amount. I went to them. I approached them verbally. Your Lordship, they said it comes to 1,25,000.
What the corporation is doing in other matters, similar matters?
I will tell your lordship. First of all, I don't have because I just received the brief. But if your lordship takes page 12 once, there are certain things I have not
No,
understood.
but if I find that in other matters you are refunding,
No, I tell you,
there is no use of
tell you, lordship, my lord,
keeping this matter.
absolutely. But I tell you, only one thing, which was, my lord, I was having some doubts.
So there is a technical difficulty.
No, that is there.
There is a technical
That's fallen from my lordship.
as a previous writ petition. In that writ petition, he's candidly submitting that no claim was made.
Correct.
But if in other matters, in case of other case, in respect of other retired employees, if this refund is allowed, then petitioner should be.
Yes, but only one or two things I would possibly require in instruction. Will kindly take page 12 once. Now, my lord, lordship sees the last bottom left hand side. It says provisional leave balance. The last line.
Provisional leave balance.
Yes. Now, my lord, this is a separate column. It goes on, and the last extreme right is EL.
And leave 62 days, 72,000 or 7,26,000.
Lordship has seen that. Now, just the column before that, it says deduct 9499.
Deduct
9499. Just the column above that.
Yes, yes.
Now, my lord, what is this deduction? Why is this deduction separate
Take
from this?
instruction count.
I have to.
Issue. File your affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner has questioned deductions made from deductions made by the concerned authority of Calcutta State Transport Corporation.
Madam, may I interrupt once?
It is
Sorry,
reflected from the pay slip of November 2023. Stop. It is submitted on behalf of the petitioner that rupees 726063. 726063. It was deducted from your retirement dues. Leave salary. It is submitted on behalf of the petitioner that rupees so and so was deducted from the salary of the petitioner, and petitioner prays for a direction to refund the aforesaid amount. Petitioner prays for refund of aforesaid amount. Stop. Refund of aforesaid amount. Stop. Next paragraph, Mr. N.C. Bihani, learned senior advocate representing corporation, has prayed for accommodation to obtain instructions. Next paragraph, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on December 23rd, 2025. Yes.
Not as usual. The usual prayer, but too short a time. Lordship wants it before.
You have difficulty on 23rd?
No, I don't have any difficulty. The difficulty is in obtaining the instructions.
List the matter under the same heading for further consideration on 8th January.
Yes, yes. No. One more aspect, not with regard to the order. Well, in representation, Lordship has seen, she is obviously referring to Rafiq Masi. When she says Supreme Court order, it has to be Rafiq Masi. Paragraph 18, I do not recollect it right now. Lordship will recollect. But possibly there is a rider in Rafiq Masi that the deduction cannot be made if it is made in excess of 5 years. So that period, whatever, that has also to be ascertained. Whether, supposing if the deduction is made, whether that period of Rafiq Masi comes into play or not. But possibly it says in excess of 5 years.
No, but a deduction after retirement is not permissible.
Until and unless financially regular. This is not the case.
Deduction after retirement.
Absolutely. Absolutely.
That is one of the rider conditions under paragraph 8.
Yes. I suddenly recollected.
Years before retirement, within a span of 2 years,
before
preceding retirement.
Preceding and total of 5 years or more. Well, whatever, if it is payable, she will be paid. Lordship. That's why I submitted, Lordship will remember more. And deeply obliged.
Item number 30.
Yes.
Tribunal is not functioning. I know there are judgments of Supreme Court where Supreme Court has observed that absence of tribunal, it approached weak.
That is already there in L. Chandra Kumar. That is already there in L. Chandra Kumar in paragraph 392 of Rogers' judgment, as it has been relied upon. There it is said that if tribunal is not there in any union, territory or state, or if no benches are available under the tribunal, then the writ petition cannot, writ jurisdiction can be invoked. But whether this writ jurisdiction can be invoked by filing a writ petition or before the a writ petition before the division bench.
The Supreme Court in 2023 says.
But how the ratio of L. Chandra Kumar can be ignored? It says previously what was the position. Previously position was this, that a tribunal, and then straightway from tribunal you can approach the Supreme Court. Now after Chandra Kumar's L. Chandra Kumar's judgment, no, the judicial review power is there so far High Court is concerned. So approach the High Court division bench and then Supreme Court. We regularly did at some point of time that file a original application before the tribunal, a date was not fixed, then matter was moved before the division bench.
There are two things that I am asking.
So that does not mean that you will come under the you will approach file a writ petition before a single bench of the High Court.
Has fixes one matter on 6.
And you need to file a writ petition. You need to file an original application before the tribunal.
That's the observation made. You also at that time was mentioning, and you also observed also informed that on 6th you also fix the matter, but the Advocate General will be appealing.
Court has requested the Advocate General to appear in the matter.
This matter can be tagged with that matter also. I'll be arguing that only 2 things, but I'm just informing also.
Otherwise, what will happen? This court will be transformed into a tribunal.
I understand the apprehension. But if I file a original application and immediately I approach the division bench, then I'll be losing one forum. That's my apprehension. And second is
Why? Why you will lose one forum? Because the division bench will pass an appropriate interim order and can send it back to the tribunal for further consideration. Question of losing forum does not arise at all.
One such case.
You must have approached this court. You must have approached this court in view of urgency, that you cannot wait till appointments are made, till chairman and the members of the tribunals are appointed. Issue is pending before our court, I know. So therefore, you cannot wait. Now, you are required to file an original application. If the same is not heard, file a writ petition before the honorable division bench. Division bench will pass an appropriate order in order to protect the right of the litigant, and the matter can be remanded back to the tribunal after appointments are made. Why will lose a forum?
I will agree because one matter where Mr. Kishore Datta was appearing as advocate general, there Mr. Datta has taken a point just because Justice, your lordship was there. In fact, your lordship was there in the division bench with Justice Dipankar Datta. There Mr. Datta, advocate general, had taken a point, since there was no judicial deliberation by the tribunal, therefore this writ petition is not maintained. Your lordship may recall matter of Horishadan Ghosh. Sorry, Shamapada Ghoda. I'll be placing that judgment when Mr. Datta.
But in that matter also, since the second original application was filed before the tribunal and no interim order was passed, it was not a straightway before the single bench.
No argument was there was no judicial deliberation. There was no application of mind by the chairman or the judicial member of the tribunal. Therefore, writ court cannot entertain this writ petition unless there is some deliberation. That was the argument.
Entertain করছে তো
Today, there is no member or judicial officer. Therefore, only register can pass a.
Then virtually this court will be transformed into tribunal. How that is permissible?
I understand the difficulty. I can understand.
How this is permissible? If I start entertaining these petitions, then this will be transformed into a tribunal. Think about the predicament of this court.
That is correct.
And there is a direction. If the original application before the tribunal is not taken up for consideration due to certain impediments, in that event, always approach can be made before the division bench with the writ petition.
I'll try to pursue your on 6 on this sport
issue.
In fact, I am appearing in other matter, but I have sought for my appointment in the tribunal.
What for?
Appointment in the tribunal.
Yes.
Before this court, writ is pending.
Two matters are pending. Matter is heard in presence of the learned advocates representing the parties. Stop. Next paragraph. Issue is whether, due to non-availability of benches in West Bengal Administrative Tribunal, a writ petition is to be entertained by the single bench of High Court, or petitioner is required to approach the honorable division bench with a writ petition. Next paragraph. Hearing of this matter stands adjourned in order to grant further opportunity to the learned advocates representing the petitioner and the state respondents to make submissions. List the matter under the same heading for further consideration. On 19 January 2020. Let me hear this matter.
But if anything is decided, if anything is decided, but then I'll be out of court, man. Well,
come back on 9. No, that I will hear separately. Come back on 19th. Yes.
Then I have to intervene there. Otherwise,
intervene. Yes, next matter.
Item number 31.
My lord, in this matter, I'm led by Honorable Advocate Abhishek Go. My lord, before petitioner starts, my humble prayer before your lordship is that the similar circumstances petition is pending before your lordship, challenging the 2009 rule. Is a development related to
You
development
are
of
praying for time, or you want to argue on the point on merit?
I'm just praying before
What
short
you are praying on
Passover. Item 51, 52 is pending before lordship 2 days list is fixed for consideration. In which matter, Lanet Senior Advocate Somendranath Mukherjee is addressing your lordship. Well, kindly hear it out with this 51, 52 so that appropriate.
No, all matters I will not take. I will.
My objection to this.
My lord, what would be the
I will not
outcome
tag
of,
all
of,
matters.
of today's
Sorry, and
observation of your lordship, which is binding upon the petitioner? My lord,
Yeah.
whatever would be the outcome of your lordship observation with respect to 2 matters, 51, 52, it will be binding
you are
up.
still protected by the order of the coordinate bench.
Yes, my lord, yes, but in those matters which my learned friend is referring. Here, my lord, I am not. Here, my lord, this
My
is
lord-
coming for the first time. I will be terminated by them.
No,
Unlike
my
those
lord,
in 51 and
just focus now, still notice was issued.
Yes.
He is not be terminated.
Pending before the Supreme Court.
My lord,
the affidavit.
And
of-
already there is a direction for issuance of notice. Sorry.
But,
Yes, yes.
Lordship, my focus, my lord, which I have challenged before, my lord, is at page 192. And my lord's order, my lord, all the orders have annexed in the report. It starts, my lord, several other honorable coordinate benches and the honorable division benches. If I directly take your lordship to page 264.
Come at 2 p.m. There are several interim orders
my lord,
on this issue.
already issued. My lord,
And at the Supreme Court has already issued
but
the past
but
direction.
there is no stay of the Allahabad judge.
Issuing show cause notice.
Yes,
Maybe.
there is no stay
Not
till
binding
now.
upon me. That is not binding upon me. It has got a persuasive value.
Yes.
And especially when the matter is pending before the Honorable Supreme Court, it's better to, since in similar other matters, interim order is passed, why the petitioner will not get the protection?
No, my lord, entitled protection, but apply.
Yes.
My lord, as my learned friend was, my lord is aware of this is those batch of matters, and my lord is already hearing Mr. Mukherjee in this matter.
But in similar cases, coordinate benches have passed interim orders. How I can ignore those orders?
Just subject to correction, my lord. Coordinate bench to an extent, my lord's predecessor, the previous coordinate bench has passed the order, basis which we preferred the
The
appeal.
division bench order is there also.
Division bench, yes, division bench, but subsequent division bench order that is passed by the uh, present acting
The only
CJ.
direction to hear the application, nothing else.
No, my
And
lord.
he was granted,
In
nothing else.
in light of what Mr. Mukherjee was trying to impress upon on the last date, that in light of Kusum Ignat's judgment and 19,
You tell me ultimately if your application fails.
if my application,
If the order, if the issue pending, SLP pending before the Honorable Supreme Court is allowed, and if I do not interfere in this matter and petitioner is removed, what will happen?
well, lord, in case I understand.
No,
what is-
already Supreme Court has passed an order for issuance of notice. No,
petitioner
yeah,
will
court
be
has to consider the balance of convenience and inconvenience.
But my lord, with deepest of respect,
Today, when the coordinate bench has passed an interim order, similar situation, when the issue is pending before the Honorable Supreme Court, stay with the direction to issue notice. At this stage, I have to weigh the balance of convenience and
but
inconvenience.
at the same instance, my lord will also appreciate when any appeal is preferred. When any appeal is preferred, there is an option, obviously, for the appellant to seek for a stay of the operation of that order. Now, my lord has to consider the balance of convenience and inconvenience in this stage also. That
But you have not preferred appeal against the order passed by the coordinate bench.
we have already that order, that item number 51.
Show me that any stay order has been passed by the
No, no,
division
no.
bench.
What I am trying to say is that
No, I am asking you. Show me any stay order passed by the Honorable Division Bench against the appeal preferred by the LIC in other matters.
no, because division bench has asked us to come before my lord and seek for.
And your appeal was also not entertained.
No, 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 no.
Only appeal was withdrawn
because
with a leave to make an application.
Why? If I may just put this question to myself.
Yes, where is the notice?
But my lord would.
Yes. Where is your show cause notice?
To kindly keep this matter with item number.
No, sorry, I will not club the matter along with that application. That will be considered independently.
I notice your lordship will see at page number 192.
Page number?
192.
Karnataka. Taking stress.
Now you have given reply to this so-calls.
My lord, after this, I just immediately filed this writ petition. I did not yet, my lord, give any reply to this.
But this is an show cause notice dated 17th October 2025.
My lord, yes. No, my lord, the show cause notice, lordship, I received in 25th of November 2025.
Where you have stated?
That your lordship will find at page number 193 at the bottom.
193 bottom.
Yes, received on 25th November 2025. If your lordship kindly sees page number.
Just a
I'm sorry.
Where is my order? Interim
Page
order
number
passed.
264 onwards.
I will grant you leave that if in the event situation so arise, you can make an application seeking variation or vacation of the interim order, which is passed today.
My lord, definitely, my lord. I'm so grateful, but
yes,
my lord, at the same time, my lord, I'll just beseech my lord, allow me to put forward these judgments. My lord kindly records my submission, then my lord passes.
Which judgments?
On this ground of passing of the interim order, first and foremost, I'll be relying upon this 1986. If my lord records, it becomes easier for me. 1986, para 83, though my lord has considered, but however, I'll be relying upon para 83, which says,
then I will be bound by this order in your application.
because my lord is already considering the same
Yes.
set of
No, it's completely different, not at all.
Yes, yes.
Because
Yes, choice is yours. Court will not hesitate to rely upon this order,
because
this judgment, but the identical issue is raised by Mr. Mukherjee in that application.
That's why
Then I am bound by the order which is to be passed today in that application. So choice is yours.
But my lord, with
Very
deepest
well.
of with deepest of
If it is
respect,
your
definitely,
choice, yes, yes.
deepest of
So
respect,
there is a direction by the Honorable Supreme Court that to stay the hearing of the writ petition.
Stay the hearing of the writ petition, which with deepest of respect, my lord, without passing
And court cannot consider the balance of convenience and inconvenience.
without, that is what the dictum of the Supreme Court to an extent.
Yeah, and during stay, if
1986
petitioner is ousted, and ultimately the SLP is appeal is allowed. Appeal is in the appeal. It is decided in favor of the development officers. Then what will happen?
Then my lord, obviously he will be reinstated
Yes.
if at all. But the
And
position of
at the
law-
time of admitting the writ petition, court cannot consider the balance of convenience and inconvenience.
But if the similar issue, that is exactly what 1986 says, Supreme Court has said, that if I may just play two lines. In our opinion, my lord, just in the middle portion, dated such and such, directing the appellants to approach the Supreme Court as similar matters were pending there. In our opinion, the course adopted by the High Court was not correct. If the High Court thought that the point raised by the appellant was the same as was pending in this court, it ought to have stayed the hearing of the writ petition until this court disposed of the other matters. I'm just relying upon this thing. Now, my lord, to an extent, the other judgment is concerned, my lord. I'll be relying upon 2007 13 Supreme Court cases, 673, para 129. This is on the proposition that, my lord, rule, it is the presumption that all the rules are to be intra vires unless it is declared to be ultra vires. Now, my lord, para 129, may I just place one small para? It is perhaps, my lord, it is the page 122, 129.
Yes,
May I-
paragraph
may I-
129.
may I? Apart from the grounds referred to by this court in the above judgment in such and such, it is important to bear in mind that where the validity of a subordinate legislation is challenged, the question to be asked is whether the power given to the rule-making authority, in the present case the central government under such and such, is exercised for the purpose of for which it is given. Before reaching the conclusion that the rule is intra vires, we have to begin with the presumption that the rule is inter vires. The court has to examine the nature, object, and scheme of the legislation as a whole, and in this context, the court has to consider what is the area over which the powers are given by the section under which rule-making authority is to act. However, the court has to start with the presumption that the impugned rule is intra vires. This approach means that the rules has to be read down only to save it from being declared ultra vires if the court finds in a given case that the above presumption stands reverted. So, my lord, the law that has been
Just a
made,
minute.
sorry, I'm extremely sorry.
But there is no quarrel to this ratio. Today, court is not declaring.
No.
Court is also permitting the LIC to proceed with the on the basis of show cause only not to pass any final order.
My lord, that
So
is
the
an
question of
interim order.
a question of deriving a presumption that it is intravenous does not arise.
Unless
Does not
but
arise.
may I say this thing? May I say
Any
this
other
thing?
judgment?
Yes,
Any
my
other
lord.
judgment?
May I explain this?
Any
thing?
other judgment? No, no, no. Any other judgment?
My lord, Kusum ignotes. I'll further rely and one more small judgment.
But you are diluting your own case in application. Today, if I rely upon Kusum ignotes, then nothing remains in the application. Think about it.
My lord, in any event, my lord.
Because the identical issue you are raising here, then nothing will remain to be decided in that application where Mr.
That's why
Mukherjee is
my
moving.
first prayer was.
So therefore,
prayer was that my lord,
in spite of that, if you want to rely upon, I cannot desist you from relying upon. The choice is yours. But nothing will be decided therein. If today it is decided based on Kusubing notes.
because my lord, in that event, kindly make it not today. Let that application be heard.
No, sorry, certainly not. If you rely upon, you can rely upon. But question, I will not adjourn this matter because the fate of the petitioner will be sealed. And at this stage, I am not. No, Mr. Counsel, I am not restraining the LIC from proceeding with the on the basis of show cause notice. But only thing is that no final order is to be passed, as it has been done in other matters. The coordinate bench has passed. If you can rely upon Kusumi ignores, my job will be lesser so far that matter is concerned. Choice is yours.
Very well, my lord. I'll take back this judgment.
In spite of that, if you want, you can rely.
No, my lord. I understand my lord's predicament.
If you rely
also.
upon this,
I understand my lord's predicament because my lord is already considering.
then everything will be considered here. Nothing remains to be decided in that application.
My lord, I understand. Very well, my lord. I take back the judgments that I have relied upon.
So these two judgments you are relying upon.
My lord, in any event, this has to be decided holistically. So if I have to rely, I have to rely upon all, or I have to take back everything, and I have to wait for my turn for item number 51. I think I'll wait for my turn for item number 51.
So you are not pressing these judgments. Take it away.
I understand my lord's predicament also, that my lord is already hearing out item number 51.
So I'm not recording that you have.
Just record my formal objections.
Yes, where is the order of the Honorable Supreme Court? Last order. 24th of November, probably.
Last order. And last order. Take to the May I have that?
Issue. File your affidavit of service.
Yes, I'm on.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Matter is heard in presence of the learned advocates representing the petitioner and Life Insurance Corporation of India within bracket for short LIC close bracket. Next paragraph. On perusal of the writ petition, it appears certain provisions of Life Insurance Corporation of India development officers within bracket revision of certain terms and conditions of service close bracket amendment rules comma 2016 are questioned and prayer is made to declare those rules ultra vires. Stop. At the same time, comma, proceeding initiated against the petitioner, comma, being development officer by issuing show cause notice dated 17th October 2025 is also questioned in this petition. Stop. Next paragraph, during course of hearing, reliance is placed on the order passed by a coordinate bench in the writ petition being WPA 14547 of 2025 within bracket Surojit Ghosh versus Union of India and others close bracket dated 10 July 2025. Stop. Next paragraph. On perusal of the said order dated 10 July 2025 passed in Surojit Ghosh Supra, it appears that coordinate bench taking note of the observations made by the Honorable Division Bench in an order passed in intra-court appeal being MAT 1222 of 2024 touching upon similar issue and in view of pendency of special leave petition within bracket civil close bracket diary number 6366 of 2025 within bracket Hitesh Kumar Goel versus Life Insurance Corporation of India and others close bracket comma close bracket comma passed interim order thereby directing that proceeding initiated against the petitioner may continue but no final order to be passed by the LIC. Next paragraph. During course of hearing, learned advocate representing the parties has brought to the notice of this court the last order passed by the Honorable Supreme Court dated 24th November 2025 on 24th November 2025 in Hitesh Kumar Goel Supra. Whereby the Honorable Supreme Court directed to issue notice and to file affidavit / reply within a specified time. Stop. It was also directed video order dated 24th November 2025 to file rejoinder. Stop. Special leave petition was made returnable on 20 January 2026. Next paragraph. Hence, it is clarified that concerned authority of LIC may continue with the proceeding initiated against the petitioner based on show cause notice dated 17th October 2025, but no final order shall be passed. Next paragraph. List the matter under the heading motion in the monthly combined list of March 2026. Next paragraph. Leave is granted to LIC to make to prefer appropriate application seeking variation or vacation of the interim order passed today if situation so arises.
I'm so great.
Stop. If you place all your cards today, then nothing remains.
No, I understand. I'm so grateful.
Grateful. আচ্ছা একটা জিনিস তুমি এসো আমি বলে দিই তোমার সুবিধা হবে এই অর্ডারটাকে পুরো ফলো করবে আমি এটা দেখেই ডিকটেশনটা দিই এটা আমার অর্ডার শুধু এই প্যারাগ্রাফটা চেঞ্জ আছে বলে দিলাম এই প্যারাগ্রাফটা দেখবে চেঞ্জেস আছে এটা একটু দেখে না এইখানে একটা জিনিস অ্যাড করবে দেখো এই প্যারাগ্রাফটার পরে হেন্স কনসিডারিং ব্যালেন্স অফ কনভিনিয়েন্স এন্ড ইনকনভিনিয়েন্স কম hence comma considering balance of convenience and inconvenience comma it is clarified বুঝতে পেরেছো clarified that concerned authority of LIC may continue with the proceeding initiated against the petitioner but no final order shall be passed ঠিক আছে হ্যাঁ
Passover matter item number 8.
Time for the petitioner. But petitioner is appearing.
they have got instructions yes
The only ground of delay, the registration certificate has not been issued. But due to that ground, the board did not allow the petitioner to fill up the form for appearing in the Madhyamik examination of 2026. But kindly
what was the last date
the 19th is the last date.
19 December is the last date
Last date for fill up the
how delay occurred
But the mainly
when the registration is when registration is formality relating to registration
kindly come to the page 23.
when the candidate studies in class 9
3rd January 2024 he admitted in the class 9 class.
No, 23.
23, yes, 23 is the. Now kindly come to page 23. This is the application made by the school authority to the board. The date of admission of the 3rd January 2023. And that application has been filed on 8th September 2023. And therefore, no
3rd January 2023
yes,
this is the application for registration
registration.
page 23 annexure R2 yes annexure P2 yes
Bottom portion, the date of admission 3rd January 2023 and the date that application has
date of admission in class 9
class 9 and
now how delay occurred
kindly come to the page 6 paragraph 6 due to the it is admitted position is that due to lack of knowledge regarding online mode the staff of the said school did not properly follow the system obtained registration certificate and as a result whereof the name of the petitioner number 1 has not been selected and incorporated his name in the said report with remark not selection.
How many students are studying in class were studying in class 11 at the material point of time
kindly come to the page 11 several students
so registration was not complete so far all the students are concerned
no. Some of the
then if it was the ignorance on the part of the school authority how the registration numbers were allotted in favor of other students
that is not but unfortunately this candidate
as it appears from your submission that it is an isolated case not like other students whose registrations is complete in the meantime
kindly come to the page
so therefore why you are making allegation against the school authority if that there
authority principal headmaster also on the petition number 2 he admitted that But my
how the registration of other students was made complete. Registration procedure of other students
that
was
has
made
been done, but
complete.
these student coming for migrated from the another school and admitted in that directly class 9, and all other students they are the class studying from the said school.
Yes, Miss Bhattacharya.
This is not the case what he's submitting. I'll allow, but your lordship must, this is not the case what he's placing.
This is not the correct state of affairs.
No. In 2023, the student was admitted in class 9. This form he have filled up in class 9, this 2023. But this student did not pass the examination of class 9. Was not
Annual
yes,
examination.
was not promoted to class 10 in 2024. So, that will reflect from his own annexure, which he
Otherwise, he or she he would have been permitted to participate in 2025 Madhyamik.
Exactly, lordship. So he is praying for
If
2026.
petitioner was in class 9 in 2023, then he should have been in class 10 in 2024, and in 2025 he would have been sent up
already given
by the school authority.
Yes. So that is not the case. Now, your lordship, not only this candidate, but he has himself annexed. Maybe he not understood what he have annexed. From page 11, your lordship, all the students who have not been promoted to class 10 in 2023. Along with this petitioner, there are 10 to 12 students. Normally, the system is when we issue the registration certificate is issued in the month in next year, that is 2024, registration certificates were issued. Now, before registration, we send the schools data verification for registration. So this is that one which we have annexed, where the school, the headmaster have signed saying that this student and other students were not selected. Not selected means not promoted to class 10. Now, what the school should
that
have
happened in 2024.
2024. Now, my lord, this student in 2024, he should have passed class 10 and got promoted in class 10 in 2025. Now, the duty of the school is to send the names of those students who have been promoted, because registration certificate were not issued to those students who failed. To send these names to, that is called edit list. Now, the board sends the edit list to the concerned school. It is board who does it. But this is the edit list of this particular school.
Where name of the petitioner?
Yes, the last name. All the students who have not been promoted and not issued registration certificate.
So, rest of the students who were promoted to class 10 in 2024, their registration number was allotted in 2024.
Enrolled in 2025.
Excluding the petitioner and other candidates who failed in 2024.
Yes. Now, board have sent this edit list to the school in 2025 in the month of January, whether they have been promoted or not. If promoted, then send us their information. So we will send them the registration certificate. Now, the school have not done so. I don't know in respect of other students, but particularly this student school have not done so. Now, my lord, totally fault of the school. That is the reason the headmaster is before your lordship. And
appoint administrator.
My lord, what I am submitting, my lord, now this.
Supersede the managing committee, appoint administrator, initiate disciplinary proceeding against.
My lord, that is what we are doing. Not maybe I don't know whether administrator or not, but proceeding is going on. Well, my lord, we have
a serious lapse.
Lordship.
Serious lapse on the part of the headmaster.
Yes.
As a result of academic interest of the student. Now, academic career of the student is at stake.
Now, your lordship, the most interesting part, the petition, the headmaster, without making any application before the board, has directly come before the court. This
along with the student.
Yes. Now, similarly situated other schools, we have allowed more than 8,000 such students. The similarly situated, we have already allowed.
Board maintain record by preparing edit list containing name of
yes,
the
this is our edit list which we have sent to them. They have done nothing. Now, my lord, we have allowed till 5th November. We have called, we have given all, we have received all sorts of applications. We called them for hearing, your lordship. On 5th December, we have gave hearing to all the schools and we have allowed all the students. But we have taken action against the concerned schools. So that is we will do it because this thing is a latch on the part of school. But in this students, we are also receiving such of applications till now. Similarly situated, we have decided we will not punish the students.
Permit the petitioner.
Yes, we will all permit.
Sit in the examination by completing the procedure relating to registration.
But my lord, a hearing is to be given to the school. So, my lord, we have decided to let him make an application to the school. 31st December, the date fixed by us to all the schools similar situated who has come before us. We will give a hearing to the school, allow the student. We will not make any harm to the students because they are of no fault, but the schools. So, my lord, to even
Who are to be heard? Schools.
the schools are to be heard. Not
And thereafter, you will complete the process.
Yes, we will do that.
Let me fix up the matter before the regular bench on the day, on the reopening date. On the reopening date.
Reopening 5th.
Very well, on 5th, and in the meantime, you take steps for
Lordship.
issuance of
Lordship. You can have Lordship record by submission, Lordship.
issue.
Only if this headmaster is very clever. He has come to know that we are taking steps against the schools. So directly came to court.
No, you take steps. I will record your submission. You take steps against the school authority. Give a word of caution to the school.
Whatever
and
step board
then
decides.
complete the process so that the academic interest of the petitioner may not be jeopardized.
No, use the word caution. Whatever board decides, board will do. Because they are doing same with all other schools.
Affidavit of service filed on behalf of the petitioner is taken on record. But in the meantime, the last date will
that
be
will take care of. What is my record my submission, Your Lordship? It is a decision.
19th is the last date.
Yes. That is for enrollment. That is not registration. Well, we'll take care of it.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner is a student. Petitioner number 1 is a student who is aspiring to participate in ensuing Madhyamik examination 2026 on allotting registration number. Stop. Petitioner number 2 is a headmaster of a government aided recognized school where petitioner is studying, or where petitioner number 1 is the student. Or where petitioner number 1 studied. Where petitioner number 1 studied. Stop.
এটা কপি দাও না যেটা দিলে
না না ওটা আপনার স্কুলের আছে
It is submitted on behalf of the petitioners that last date for allotting registration number in connection with 2025 in connection with Madhyamik examination 2025. Madhyamik examination 2025 is 19th December 2025.
19
Madhyamik examination 2026 is 19 December 2025.
Enrollment.
fill up, not
No, enrollment.
2025.
ওটাই enrollment form.
And till date, petitioner number 1 is not provided with registration number. এর আগে মাধ্যমিক এক্সামিনেশন থেকে 26 বলেছি না 25 বলেছি দেখো তো, হ্যাঁ ঠিক আছে। Petitioners pray for necessary direction upon the West Bengal Board of Secondary Education within bracket for short board quote unquote close bracket for providing registration number which would make the petitioner number 1 eligible to participate in ensuing Madhyamik examination 2026. Stop. Next paragraph, Ms. Koeli Bhattacharjee, learned advocate representing board on instruction submits that petitioner along with some others,
total 24,
some other students of the school within bracket Padonganj High School, Padonganj High School, Boghat, Hugli, close bracket. Failed in class 9. Otherwise, he would have been permitted to participate in Madhyamik examination 2025. Stop. It was the duty of the petitioner number, it was the duty of petitioner number 2 to send the names of failed candidates who were not promoted to class 10 in 2024 to the West Bengal.
Failed candidates, they have said in 2024 when they have said this candidate not selected means failed. Now when they are promoted 2025, when they are promoted in class 10, the school's duty is to we have sent the school this edit list. You see, this student failed in class 9. So now in January, the session starts. So they must have been promoted to class 10. So along the students who have promoted to class 10, send us the name. So that
in 2025.
In 2025, so that we
so
can.
At that juncture, those names were not sent.
Yes.
Acha,
Class 10, yes.
So the exercise was required to be performed in 2025.
Yes.
By the school.
By the school.
Sending the names of failed candidates along with regular candidates.
Lordship.
Ki bolcho? Who were not promoted to class 10 in 2024. In 2024, in 2024.
But promoted in 2024.
Along with other candidates who were promoted to class 10 in 2025. Stop. Such departure on the part of the petitioner number 2, being headmaster, resulted in led to a situation by not completing formalities relating to issuance of registration number and certificate in favor of the petitioner. Stop. Next paragraph. However, it is specifically submitted on behalf of board that on completing necessary formalities, registration number will be allotted to the petitioner in the month of January 2026. But prior to that, school authority, prior to that, petitioner number 2, being the headmaster of the school, shall be granted an opportunity of hearing.
Provided you make an application before board. There is no formal application before board regarding this thing.
Stop. Shall be granted opportunity of hearing before the president of the board. Before the president of the board. Stop. Petitioner, stop. Petitioner number, stop. Stop. Next paragraph. In view of such submission made on behalf of the board, respondent number 2 is directed to make an application to the president of the board indicating details of the petitioner number 1 for completing the formalities relating to registration by 48 hours from date, based on which president shall grant an opportunity of hearing to the petitioner and also shall pass necessary order for completing formalities relating to registration of the petition. Number 1. By second of January 2026.
Second, I don't know, my lord, whether the office is open or not.
Why not?
খুলবে জানি না সরকার খুলছে হ্যাঁ খুলবে government office I don't know when it
2nd January 2026. Stop. List the matter under the same heading for further consideration before the regular bench on 5th January 2026.
fifth. My lord, fifth is combined list, sixth. Otherwise, it will get in the combined list.
Very well, on 6th January 20.
It will be.
Before that, by 2nd, board has to complete it. If 2nd is holiday, by 31st, complete it.
No, 31st, your lordship, board will give hearing to all these schools on 31st. So, my lord, on 31st, after giving hearing and this procedure to be completed, it will take some time.
No, but it will take the entire issue just before the examination, because examination is scheduled.
No, 2nd February.
No.
We have time. Because my lord, 31st is the hearing.
So far, this matter is concerned, since there is an order of the court, complete the procedure by 31st. Next.
6th January.
So that you come up before the regular bench with the order of the president relating to completion of registration of the petitioner. Number 1.
Lordship.
Item number 32.
Item number 32. Durgapur Project Limited matter.
Yes.
Lordship has decided and last occasion directed me to put the necessary correction in the matter.
Would that interest matter?
Yes, only interest.
Retired on 31st January 2025.
Yes, Lord.
Well, my junior is there, my lord. I taking him.
Yes. Yes, disposed of. Interest on gratuity and leave salary.
Item number 33.
You have filed affidavit of service?
Yes, Lordship.
এই অঞ্জন
যে বোর্ডের মামলাটা যে
Affidavit of service, Lordship. My Lordship corrected.
Yes.
Item number 34. Item number 35.
Lordship. 31st. Lordship retired on 31/10/2023.
Item number 36.
I appear on behalf of the petitioner, my lord. I am handing over my affidavit of service. My lord, the petitioner who is before your lordships was desirous to take up the recruitment process for constable in the Central Armed Police Forces, SSF, Rifleman GD, in Assam Rifles and Sepoys in Narcotics Control Bureau. By your lordships, he was qualified in the written, that is the computer-based, I'm sorry, that is the computer-based examination. After he was qualified, he was called for the physical endurance test and the physical stamina test. He also qualified in that. Now, my lord, in the medical examination, he was primarily found to be an unfit on the ground of having flat feet. I shall not waste flat feet. Lordships may kindly takes up page 52. I'm taking your lordships straight away to the most important part, that is showing us flat feet. Yes, that is the page 52. That is the report of the detailed medical examination, which shows that he has got flat feet. Now, lordships, he preferred for a review medical board examination. That is available at page 53, the very next page. Now, my lord, this is a very important, that upon the brief of review medical examination and finding thereof, it states mild flat feet with decreased, something is written over there, opinion as per specialist opinion. Now, my lord, this mild flat feet is not, something is written over there, my lord, that I cannot make out.
Yes.
But this is something, my lord.
May I take instructions in this matter?
No, my lord, may I. My lord, I have not yet finished. So, this is as per specialist opinion. Now, my lord, yes. Now, my lord, I have got two folds of submission. Number one, in the review medical examination, they have brought in something new, which they could not have done. What they have brought in? They have brought in the point of pigmented navy on back, That is the medical term called as Baker Nevers as per specialist opinion. Now, my lord, my twofold submission is this on back. That is, my lord, all of us have such birthmarks, and that is the point for which I have been. This is, my lord, particularly when mild flat feet is allowed. This is my one limb of submission. Is second. X. For but for Y. Yes. Yes, there is a bar. Lordship kindly takes up page 101. The guidelines for the review medical examination, I have annexed the entire part. It starts from page 100 at page 101. Guidelines for review medical boards. The very first point which has been stated, review medical board should examine the candidate specifically for the deficiency for which the candidate has been declared unfit. However, for obvious defects, infirmities contracted after initial medical examination, review medical board may give its opinion. Also, the medical terms used as cause of unfitness during the initial medical examination. My lord, very well, my lord. May I not go into that? But even if I take that, in that event also I am saying Baker Nevers is not a disqualification. This, yes. Yes, my lord. I have also taken that point. And my lord, I am covered.
Yes, my lord.
And because, my lord, and one more thing, my lord, if your lordship so desires, he can also be sent for a review medical. That is. Because, my lord, my specific point is that these are birthmark. In the detailed medical examination. And my lord, may I kindly show your lordship one thing, that mild flat feet. I am then also I am through, because I am covered by the decisions of other high courts which have got the persuasive value. And lordships, may I kindly show lordships only one thing, my lord. That is the part where it clearly states that, my lord, the having the point of mild flat feet is allowed. Lordships may kindly takes up page 54. Yes, my lord, therefore, my lord, no, for your lordships, Baker Nevers only. Yes, my lord, and they have to specifically show, my lord, Nevers can be of various types. Nevers can be of various types. And the 2000. May I humbly submit, my lord, kindly lordship advances the date because my lord, and I've got one more submission, my lord, because here the specifically it states that the nevus would only become a disqualification factor for me if it hampers the regular operation. My lord, kindly sees, my lord, because if it interferes with function, because my lord kindly records it, because if that is to be done, if it interferes with function or are exposed to constant irritation, then only it is a disqualification. My lord, they have not recorded. No, lordship, they have not recorded it in my RME. And the 2015 guideline. Well, there, no, one is May 2015 one, but that is the first one, and the second one 2021. As your lordship pleases, grateful, my lord.
Item number 37.
Decisions of the high courts. And my lord, may I lordship, let the medical examination be done, my lord, because if later on, if it is found, my lord, if it is found, my lord, he is suitable, my lord, again he will be sent, my lord, it will be a grateful.
Item number 37.
This is my affidavit of service. My lord, here my candidature has been rejected on the ground of removal of tattoo. Existing tattoo is the ground for rejection. There is in the medical guideline. But the prior to participated in the examination, the candidate removed the tattoo in Machal. For that reason, he participated actually. Well, that observation also in the rejection slip that the tattoo removed. Well, on that ground, they cannot. That is my humble prayer. For your lordship, 22, page 22 of my return. My lord, 4 ground were assigned. A review report. My lord, DME is 21. Page 21, just prior to that.
4 grounds.
4 grounds were assigned. Yes. That 3 grounds I have passed. They have declared fit. Only 1 ground assigned, that is the due to removal of multiple post tattoo removal, scar mark present over the right forearm. That is the ground. And medical guideline also reject. There is a specification that the existing tattoo is the ground for rejection. In only one. Yes, that is the only ground. And my lord, last occasion, my lord, the coordinate bench also sent this type of matters to the commando hospital. Commando hospital found that the removal of tattoo is not a ground. My lord, in another matter, not a ground for rejection, because there is no existence of the tattoo. It's only a scar mark.
My lord, yesterday evening I have received this view. I have sought for the instruction. I have yet
My
to
lord, I am
receive
saying
it.
then,
Some
my lord,
days may be given to so that I may receive this. But still that I have to see whether check it up that whether it has been done in a identical case. It has been done or not.
Scar mark present, removal scar mark present over right forearm.
But this is illegal.
There.
That is
removal of the tattoo, that should be.
scar mark is also yes.
Scar mark, only mark, not tattoo. They have specified that. Star, not star, not scar. That scar. My lord, if the tattoo has been removed, then the one mark is mark. Yes, that's not star. No, no. Scar. Yes, unknown removal date which forum date which may something is there in combatized duty. I have specifically that mentioned in the paragraph 8 of my writ application. Yes.
I'll take instance.
And another thing you lost is next page 23. Last year occasion also that was found, the tattoo removed and declared fit. In this case also, same candidate. My lord, the cutoff I could not come under the purview of cutoff marks. My lord, I could not come within the zone of consideration of cutoff marks. He was at it. Yes, yes. Remove that. Declare fit. Zone of consideration. Again. No. That scar mark is there. That scar. Part to earlier selection process I have removed. At that point of time, I could not come under the zone of consideration. Now I have better marks. I can maybe come under. Yes. After removal.
Well, whether that is true or not, I have to ascertain from the
23,
from the records.
Page 23, date is also there. 16/10/2020.
That my lord, I'm on page 23. That if no, no. So I'll take instructions to that effect that why this discrimination has been made. I'll take instructions to that effect that why he was then declared fit and now why on the same ground he is being declared unfit. I'll take instructions to that effect. But the page is, my lord, illegible. I cannot get through everything. Whether that submission is correct or not, we have to, and many portions are illegible, my lord. So I have to get from their record also.
Revised guideline says that the tattoo in right forearm, there is a measurement, and the national emblem and the religious purpose, if the tattoo is within the parameter of the measurement, then it accepted. Left forearm, it also there. It is removed, nothing is. No, nothing is there. Nothing is there. in the medical guideline. I have searched out every point. Also in the scamming, tattoo is the tattoo is existing. Or national yes, sir. Then is fun. Scam is not a bar. Medical. Otherwise, they cannot declare fit in last year. (24)
Well, 23rd, I have some personal difficulty. If it could be on 24th. No. That is my meeting in my son's school. They've called me over there. My, grateful to your lords.
Yes, then monthly list, I will be in difficulty.
Grateful to your lords.
Item number 38.
38, may I please, Lordship, I am for the petitioner, this is my PDP.
But I am for the respondents.
My lord, here also, Nevas in the left, my lord, kindly come to page 22 of my writ application. Nevas on the left, in the left, Leon region. Page 22 of my writ application. Well, thereafter, the review medical examination, page 23. Varicose epidermal nevus. Well, that is the birthmark. Law and regio. My lord, there is a birthmark in forehead. There is a birthmark in forehead. Left Leon region. Well, the page 23 is the rejection review medical examination also declared is use term use another. Well, the very mole birthmark is black spot. Well, here also last year in the medical examination is 2024. Oh, sorry, I'm extremely sorry. It is in the here. In what? In forehead, not forehead. There is a Leon region, my lord. This is the nearest to the abdomen. Yes, there is fine. There is. Yes, I am extremely sorry. Not the forehead. Here, my lord, page 23. Yes. Well, page 23 is term has been used another, but varicose epidermal nevus. Malat same, malat. Reason is same. More same. Malat epidermal nevus. Epidermal nevus. Malat kindly come to page 25. Last year also I have been rejected on DME on the same ground, and I preferred review with medical examination. The review medical board declare as a birthmark, specifically birthmark. It is a birthmark. Page 25. Page 25, 24 examination. Malat, it was on October 2024, the fit, and they have been specifically written it why they have declared fit. Birthmark on chest. That point. Yes. Here also one more and
different ground, man.
different place, but both are. That malad the both terms also same use that. Both the mark are same. They have found both the mark are same, but one they have declared fit and another they have. That is
This matter also I was praying for some time, if I may get the instruction to all these matters, but along with that matter 6 or 7 other matters I have been given brief yesterday. I have sought for instructions, and it may also be taken up on 6th January so that I may come up with you.
পরেরটা কি আছে?
না, পরেরটা তো স্যার আছেন বলে।
পরেরটা একটু কালকে একটু নোট টু দেখুন। Review medical report dated, my lord, 2nd December 2025, page 23.
I'm grateful.
Much obliged, Your Lordship. Grateful to you. My next matter, my lord, I pray for an adjournment. Kindly takes up this matter day after tomorrow, because Here is I want to use a supplementary.
Item number 39.
The petitioner went to the medical expert and he has declared fit. That's why I should rely upon that document, and if it is not in record, then your lordship will not hold.
RME report says unfit. Page 22.
Two ground has been assigned, bow legs and the little finger deformity. Something is there, deformity. My lord, I have specified that in paragraph number 8. Bow leg and the little finger of both hands deformities. Little finger extension deformity. Extension deformities. Deformities. My lord, the little finger is still bent. And having that deformity. And bow legs. The bow legs is the 7 centimeter. Yes, my lord.
Bow leg is a good ground for rejection.
Yes, bow leg is a better.
What is
Right.
Item number 40.
40, my lord, I am for the petition.
I am for the respondent.
Here, my lord, the page 20 is the rejection, first rejection by the DME board. My lord, overweight and hypertension, tricardia. Tricardia. The fraction fluctuate of the BP, I think the meaning is there. Well, in overweight, I have passed page 21, but they have rejected my candidature on the ground borderline left verticular hypertension. Well, what does it mean? I can't understand. Well, here the BP has been verticular hypertrophy. The ECG was done, it was normal. The BP has been taken, that is also within the permissible limit as per given by the medical guideline. And page 22, kindly come to page 22. Here also the doctor, after examining everything, declared fit. Gandhi Memorial Hospital, Kollam.
No, I would make a similar prayer, my lord, to keep it in January so that I can come up with. I'm grateful to you, lords.
No, I That's why I firstly submit that if my learned friend is any problem, I can. I should be for it. Become now. এই 40 42 তো হবে রাজা হ্যাঁ আর রাজা হালদার আগে
Grateful.
much of
Item number 41.
40 my lord, I am for the petitioner. Raja Halkar. This is my
I am for the respondents.
my lord, here my candidature has been rejected on the ground of my lord high page 29 multiple total cavation cyst. Well, cyst is a ground for rejection if there is any cyst. Page 30 31 my lord. Page 30 and 31 I went to the Malda Medical College and Hospital. Sorry. A detailed medical examination, that document have taken by the review medical board. I have not make any copy of that, my lord. That's why this petitioner could not able to produce me that copy, my lord. But the ground has for which the review medical examination has been done, that has been mentioned in the clause number 1. One ground was assigned. ওটা হচ্ছে হ্যাঁ সেটা নেই কিন্তু ওইটা না এটা আছে ওটা হচ্ছে নো অ্যাক্টিভ লেজার লাস্ট পেজটাতে লিখে Yes, I have, sir. I have, sir. Multiple. এটা 40
Much obliged.
inform করবো
Item number 42.
To my lord, I am
I am for the respondents.
my affidavit of service. Here, my lord, page 21, the DME, detailed medical examination report, hemoglobin 11.7 and overweight, BMI 25.82. My lord, page 22, unfit, I have passed the hemoglobin test because when the measurement was taken, hemoglobin test has been done, it was come 12 point something. That is within the permissible limit and declared fit. Unfit on account of overweight of 7 kg. My lord, page 23, as per my height and weight chart, doctor measured 78 kg of my weight and 177.7 centimeter is my height. Thus, the patient is within the BMI range. He has calculated the BMI 24.89. Yes, I have. Yes, yes. Yes, yes, yes. I must show. No, no, no. My lord, I have given one extra copy. Height measured in the PST. Height measured in the PST, my lord, 77.7. 77.7. And weight measured in the PST, 81.50 kg. And at the time of age is, my lord, 26 years. 32, that gap. Eight centimeter. Yes. 177.7 centimeter. 177.7. That was PST, and RME, it was measured at 79 kg. Sorry, my lord. It was measured at, yes, 79 kg. My lord, page 22. Brief review medical examination and finding, clause 2 and 2, number 2, clause 2, number 2, over 79 kg. They measure at the time of review medical examination.
My lord, I have got a copy just now, where it is that VA should be between 60 to 73 if it is 178. 70, 79.
79. Malad, the plus 5 kg plus minus. Malad, if I overweight by 5 kg, then I am coming with the under the purview of zone of consideration. It's if it is rounded off on 780, then 75 is the yes. It should be rounded up 180. Yes. Yes.
75.
The weight should be maximum 75.
Minor.
Plus minus 5 kg. Malad, if I more 5 kg more overweight, then I will come under the zone of consideration. That 75 plus 5, 80. Up to 80 kg, they will accept. That is the clause 2D says so. Plus minus 5 kg. If it is rounded off with 180, then maximum weight should be 75 plus minus 70. If I have 80 kg, then I will come under the zone of consideration. They cannot disqualify me. That is the point. Yes, they have stated 70. Yes, but they should.
Because plus minus 5 kg does not come in your age. Means if 5 kg weight is then even then you are
Malad, reduce in case of low weight, underweight.
nothing. This plus minus 5.
Plus minus 5 kg means, Malad, if I underweight by 5 kg, then I will be considered.
You are adjusted as overweight by 7 kg.
7 kg.
So if the 5 kg will not come to the age.
Malad, they cannot, Malad, my height is 77.7. They have measured 177.7. That means 178. তাহলে 73 হচ্ছে ম্যাক্সিমাম 73
স্যার 73 আর 7 হলো 81 সেটা 81 হয়ে যাচ্ছে সরি 80 হয়ে যাচ্ছে আর কি বলছো ওরা
72
হ্যাঁ তো ও তো 73 ওই জন্যই 7 কেজি বলছে
79 kg. As such, not matching with their observation. 72 kg, I will come. If that is meaning 72, then I will come under the zone of consideration. And if it has been 5 kg plus, then also I am coming under the purview of the zone of consideration. -79 minus 5 kg. If that is so.
This is just borderline. This is just borderline. Not 7 kg, but 6 kg overweight. So even if 5 that is given, it is not coming. So then
75.
And it is 79. If the difference is 4,
Only 4 kg. No, makes no sense.
178 হলে তো এটা 73 তো
73 হলে তো ফির
না 73 হলে তো ওটা তো এখন
73 প্লাস 5 কত 78 73 প্লাস 5 78
73 plus 5
78
হ্যাঁ
then 50 can come 177.7 আমরা 178 পেয়েছি
but what he is saying is to calculate by one taking 178 into consideration, then that is 73. So
178 in consideration.
yes,
If that be so,
Then 73 is the
because it is 177.7. So then if it is 73, then
reasonably wrong to ask you that if it is the height is 177.7, then the authority considers 178 or 170.
না উনি বলছে কোনো নর্ম বা রুল আছে যেখানে বলছে 177 হলে 178 ই কনসিডার what he is submitting matter that if it is more than 0.5 the next is calculated, so 178 next 178 will be, so it will be considered right, so 178 will be
is to be
178.
178. Then maximum weight is 73. But at 73, they have rejected 79. Yes, they have finding as given.
Yes, that is not applying.
My lord, they have found that 7 kg more. My lord, it's not make any sense.
Very well. If it is 70,
It's 6.
because 178 for height is 177.7.
Yes.
It is rounded off to the next higher star, meaning that thereby 178.
178, 78. Yes, my lord. That is my submission. Permissible. Wait.
Your weight is 79.
79 kg.
So weight is 79 kg. Then it is on the higher side by 6 kg.
By 6 kg.
Therefore, even if height is you are not.
You are
doesn't
not coming.
qualify.
20 page 23, my lord, kindly have a look. That's why I am paying. That my lord, 1 kg. There, my lord, if that calculation is given by the authority concerned, then I am shortfall of 1 kg. My lord, overweight for 1 kg. My lord, on
Already you are
yes, by 6 kg by
after giving exemption.
Exemption.
Exemption. Relaxation. There will be
One,
by
1 kg. Well, that's why I'm paying reliance upon the page 23. That's only that ground. Otherwise, I should not approach before your lordship. Well, 23, kindly have a look. My weight is 78 kg. Major, doctor measure and BMI also calculated. Not only that, the weight. No, my lord, a PST more weight. At the time of PST, there was a 81 kg. PST level, it was 81 kg. In RMA, it was reduced.
What was the weight measured in DME?
DME, that has not been mentioned. If that be mentioned, that the weight my weight is being mentioned there, then it will easier to us to calculate this thing. They have not mentioned. No. 21. Page 28. Page 28. 21. Sorry. 21. There is no whisper about my weight.
But they are also
But
minority stated that his overweight and BMI is 25.82.
Well, that weight which has been taken at the time of DME, it is with the authority concerned. If your losses go through that,
But a normal
weight, then I have no
normal range of BMI, what I get from page 23 is up to 24.9, and here it appears that BMI is 25.82.
হ্যাঁ এখানে উনি ক্যালকুলেট করে
আরে এখানে তো তোরই ডকুমেন্ট, এটা আমার তো নয়।
এই তিনটা আমার
আরে এখানে 24.9, তা এটা ম্যাক্সিমাম নর্মাল, তোর তো ওইখানে ওটা 25.8
এইটা উপরেরটা আমার কত
হবে না। এত এই তো 24.8 নয় 24.9, তুই আছিস ওখানে, কিন্তু ওটা তো তোর এইখানে বলছি বলছি অ্যালাউ কতটা হবে। নর্মাল রেঞ্জ যদি 24.9 অব্দি হয়, তো তো এখানে 25.82, তার নিচে কি তোর নেমেছে? এখানেও তো 25.82।
height my lord PST my lord certificate page my lord to 18. Much obliged, Your Honor. Obliged. Make it.
Item number 43.
My lord, I am 43, item now 43 and 44, and this not today because my advocate record Tanmay Chattopadhyay is not to come because his uncle was died. No. Yes. Forty and 44.
Same matter, Lordship.
44.
44 and for the state Lordship.
Monday. Monday.
এটা 44, 43 যারা ওরা চলে গেছে, আমি ওদের আসতে বলছি, আমি বলে দিচ্ছি। আচ্ছা 14 জানুয়ারি, 14 জানুয়ারি। আমি বলে
Item number 45.
But 45, 46 can it be taken up on tomorrow? A supplementary affidavit is required to be.
Well, let it be taken up after vacation.
Yes, my lord. Page 23, 22 is the first rejection order by the accessory nipples on the right, that is the ground. Page 22. Page 22. It cannot be a ground for rejection of unemployed youth working, practicing so long, and after qualifying 3 hurdles, now he is rejected on this ground. Yeah, 23. Malad. That is the in a government hospital. He has consulted with a surgery doctor and given the certificate that it is a merely a spot and looks like a nipple and it will not harm any duty or anything. No, nothing, nowhere, nowhere. That I have given the guideline. Nowhere it has been said that is a nipple. Review page 23. Page 23. Dated, my lord, 26/11/2025. My lord, my lord, it will be 28. Yes, yes, surgery. Much obliged.
Grateful to you. Item number 46.
46, may I please your lordship kindly.
I am for the respondents.
For medical, my lord, expert opinion. My lord, here, the page 21 is the detailed medical examination report. 3 grounds has been assigned. 4 ground has been assigned. Out of 4, 2 I have passed. 2 grounds for rejection that has been indicated in page 22. Last in box, multiple hesitation mark on left forearm and another is middle finger deformity. My lord, I have middle finger, my lord, in bend in outside a little bit, deformity. My lord, that ground has not also, my lord, not a valid ground for rejection. My lord, multiple hesitation marks. Hesitation marks on left forearm. Yes. Foreground. First one is cubitus valgus, means my lord, carry angle. I have NDME. Foreground for NDME. In RME, page 22. I have passed two ground and rejected on two ground. Multiple hesitation marks on left forearm and middle finger deformities. These two ground has. My submission is that, my lord, I have checked it both by the doctors. My lord, I want to file a supplementary affidavit annexing that document. That the multiple hesitation marks in my forearm, it has been due to an accident. That is not a ground. I am fit on that surgical point of view. And another is the, well, the middle finger of my both the hands. It's my by birth that has been declared. But it is not hampering any duties. Revised guideline in scar mark, burn mark is there, but hesitation mark in left forearm, nothing. And middle finger, I never seen this type of ground is stated in the medical guideline. Deformities. This type of ground, nowhere it has mentioned.
To take instructions.
Well, in that event, well, I shall give a liberty to file that supplementary. To me, much obliged. Grateful to Lordship. Grateful to
Grateful to your lords.
Thank you.
Item number 47.
My lord, I appear before the petitioner. File my affidavit of service. My lord, the petitioner before your lordship is the widow of a deceased medical officer. My lord, the petitioner before your lordship is the widow of a deceased medical officer who superannuated from the service in the year 2011, my lord. He is superannuated from the service in the year 2011. My lord, in Bakura Swamiloni, my lord, Medical College, my lord. My lord, don't. My lord, if I may satisfy on that count, my lord. My lord, initially there is a disciplinary proceeding during his lifetime, my lord. Well, my lord. My lord, my lord, if I may appraise your lordship on this count, my lord, we are here, my lord. I am here only for the purpose of enforcing a right which has been crystallized in my favor, my lord. In favor of the my lord, during the subsistence of my husband and subsequent thereto in my favor. My lord, there are two counts on two folds, my lord. One is regularization of an ad hoc period, which my husband made an application during his lifetime, which has never been acceded to at that relevant point in time. Subsequent thereto, there is a disciplinary proceeding for which the pensionary and all the retirement benefits has been stayed. Subsequent thereto, my husband, the husband of the petitioner during his lifetime approached the state administrative tribunal. There is an order setting aside the disciplinary proceeding, and thereafter, my lord, several representations were made by my husband of the ad hoc period, and as well as the retirement benefits, the terminal benefits. My lord, my lord, in that event, my lord, kindly grant me so that I can come back with some judicial precedents to satisfy your lordship. My lord, my lord, kindly grant me some time so that I can satisfy your lordship. The maintainability, my lord, I appreciate. My lord, the lordship be pleased to take up, my lord, page 36 of my writ petition for once. My lord, the husband of the petitioner, my lord, died on 22nd of January 2020. And the letter which gives arise this cause of action, my lord, this is at page 36, which is a post death of the husband, my lord. That is on 4th of November 2020. That is my first prayer, my lord. Under the government of my lord, so far, my lord, even if my lord, I just try to appreciate, my lord, even if I forego my first prayer, my lord, so far as the ad hoc period is concerned, the second prayer, my lord, that arises. But my lord, this particular thing arises only after 4th of November 2020, after expiry of my husband, my lord. After expiry of my husband. My lord, in that event, kindly grant me so that, my lord, I can obtain knowledge from.
Particular period of service rendered by her husband and pension due to death slash superannuation of her.
My lord, my lord, my lord, what I've been informed, my lord, kindly approve what I've been informed, my lord. At present, at this juncture, my lord, the tribunal is not functioning. There is no member available.
Item number 48.
So I beg to appear on behalf of the petitioner. Evident service. Okay, my lord, on earlier occasion, Lordship petitioner approached before this honorable court for illegal Lordship, on earlier occasion, my lord, petitioner approached before this honorable court challenging the illegal termination of post of the ASHA, my lord, in district Malda. And my lord, there was a certain direction which to be followed by the SDO Malda, my lord, that has not been followed. That's why, my lord, petitioner come with an application for contempt. In contempt application, they file one report, my lord. They admit their mistake. They have done a mistake. That report already has been attached in my writ petition, my lord. And my lord, that is the page number 69, bottom portion. My lord, may I read, my lord? It also informed to all that Lordship. And I have been given liberty to approach before the honorable court to get the justice on basis of that.
29 or 26. That page 26. ভুল বলেছেন আপনি। Put it at page 26.
Lordship. Lordship.
Page 26.
Lordship, and page 24. Lordship. Lordship, this is the total story which has been narrated by their report, my lord, which has been filed in the contempt proceedings. My lord, in the page number 69, my lord, of their report in bottom portion, kindly have a look. Lordship, Lordship, the meeting, my lord, which was held on 6 June, my lord, that is starting from 68, page number 68. There is a Lordship, Lordship, Lordship. Lordship, I am relying the page number 68, which is the meeting was conducted in terms of order of the Honorable Court, that is 6 June. That is the resolution passed by the SDO Mamla. Lordship. 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 Lordship, I am Lordship.
Could I file the report? Could I file the report, bulky report I am carrying it? No.
Item number 49.
And I appeal for the
For this one.
Pursuant to minus dash reaction, my lord.
I have filed my
The respondents have filed their report, my lord. As
I could not
First, my lord. First, that in our advertisement, we have stated that there is a crucial date, page 44, crucial date for determining the age limit and post qualification experience shall be 23rd December 2025. It is the advertisement says, it is the date. We advertisement said, kindly come to page 44. Page 44, plus 13, 1 3. Page 44, this is it start from plus 13. 13. The crucial date for determining the age limit and post qualification experience shall be 23rd December 2023. And the date of declaration of results to issue of the mark sheet shall be deemed to be the date of acquiring qualification, and there shall be no relaxation on this account. Post qualification experience and post for the post level shall counted from the said date onwards. From on that day he was not qualified.
No, my lord. By on 31st January 24, my lord, I have the requisite qualification. But it is con. Yes, my lord. It is con. But in the case of Ashok Kumar Sonkar, my lord, the Honorable Court has held that the qualification is the last date of application is to be taken as a cut-off date for acquiring the qualification, my lord. Yes, ma'am. Yes, ma'am. And my lord, and
Yes.